Allegiance. Dear Heavenly Father, let your grace and mercy be upon us. We ask for your assistance, O Heavenly Father, as we go through this day. Encourage us, O Lord, and keep us up. Let us be a help to those who are in need. Strengthen us where we are weak. These things we pray in thy name. Amen.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Council has an agenda. Chair would ask, are there any additions, deletions, or corrections to that agenda? Hearing none, the chair moves that the agenda be accepted with unanimous consent. We also have minutes from the May 26th meeting. We've had a chance to go through those minutes. Are there any additions, deletions, or corrections to those minutes?
Actually, I don't think we have those minutes.
We don't have those minutes. Thank you. So strike that. Do we have the... Don't have
We
the
do have
June meeting?
disbursements. The disbursements are, yes.
Let's move down to our disbursements. We have disbursements from June the 30th and July the 7th, and also July the 14th. We had a chance to go through those disbursements. Ask any question of Ms. Lane, our finance officer. Any additions, deletions, or corrections to those disbursements? Hearing none, the chair moves that they also be accepted with unanimous consent. Okay, Council, moving on to the agenda. First item we have is a matter of reconsideration for a letter of support to the Maryland Congressional Delegation for H.R. 7120. This is the Justice and Policing Act of 2020. This letter was moved by the Council at our last meeting. According to the rules of procedure, only a member who voted who affirmed the act, could actually bring it back before council. And I believe Mr. Lesher, you asked for it to be put back on the agenda? Okay.
I did.
Okay.
Mr. Pack, I'm prepared to make that motion if that's in order now. I also see that we have Sheriff Gamble in attendance here, and since we have the opportunity to hear from him, do we want to open that, provide that opportunity?
Well, let me take your motion first. I need your motion to be
I will then start with a motion to reconsider.
Okay, motion
Second
to reconsider, second also by Mr. Callahan. Before we call for the vote, we will open it up for comment. So, we'll open up to you first, Mr. Lesher.
Well, while it remains clear to me that police reform in America is an important topic and necessary and timely, and that there's a federal role to be played in that, in my view, this council made a significant error in advocating legislation without consulting first with our sheriff, and I've personally apologized to him for this mistake. Sheriff Gamble has considerable expertise in addressing police abuses, and he has recommended a number of matters for police reform. I also think that since Congress is clearly now moving slowly on this, I would prefer that we withdraw our approval of the letter that we authorized on June 23rd and take our time with due consideration and advice of the sheriff to craft a replacement that addresses specific policy issues.
Okay. Any further statement of council?
Mr. Pack, I have a statement to be read from Mr. DeVillio, who's absent tonight.
Sure. Why don't you read that for the record as well?
I voiced my concerns regarding sending a letter about federal legislation, but ultimately voted in support because I believe everything can be improved. After speaking with our sheriff, I realized I should not have sent a letter in support. I've always prided myself by reaching out and listening to subject matter experts. I expected to have their guidance during the meeting and ultimately take responsibility for not inviting them there. Thank you, Frank DeVillio, Talbot County Council.
Okay, thank you for reading that into the record. Mr. Callahan, anything from you?
Yes. Last meeting, it come up that we wanted to talk about and support this letter. I was kind of led to believe that we're headed in the right direction. I made a mistake. I should have, I brought up that we wanted to talk to you, Sheriff Gamble, And that was my mistake. I was on point. The one that had it right was Mrs. Price. She's the one that really knew where we were headed with this. I should have followed that lead. I was led down the wrong road. I talked to you. I talked to Scott. I want to apologize for some of your staff and really all the officers. You know, it probably felt like we weren't behind you, and that's far from the truth. We are behind you. We have your back. We want to be able for you to have a very safe community. You guys are doing a phenomenal job, and I'm talking to you guys, all the deputies, all the stuff that you do. We really, really appreciate it. You're the ones that keep us safe. You know, when you're up here doing a job like this, it's very, very difficult. There's a lot of things. I think a lot of people do want police reform. I think there's a lot to it. I think you guys will get into a point where you tell us in the sense that you're headed in the right direction. I don't want to tell you how you do your job, okay? Because that you're good at it, and that's what we that's what we want you to do. We want you to protect us. So I felt like we were probably stepping on your toes, and we shouldn't have done that. So like I said, I think we're headed in the right direction. Sheriff Gambrill, I really appreciate you talking to me several times about what you thought about some of the bill that we were voting on, and there were some things in there that you felt that needed to be looked at that wasn't right for your department and things in general to keep us safe. So I really appreciate the opportunity for you to tell me some of the good things and the bad things in that bill. And thank you, Scott, for doing the same thing. And thanks for protecting us.
I'd like to say that since the sheriff is here and has taken the time, I would like to give him an opportunity to come up and address the council. I think it's appropriate. You should have been here 3 weeks ago, and I hope that the council agrees that we should have you come up and speak.
Do you wish to be heard, Sheriff Campbell?
I would.
Okay, come on up, please.
Thank you, council. Thank you, Ms. Price, for the invitation to speak, and thank you for your foresight a few weeks ago and to vote no against this letter of support. Mr. Lesher, thank you for your phone call quickly afterwards, and thank you for the opportunity to allow me to share some of my thoughts on the bill and where I think police reform should go. There's no doubt that police reform is needed, and thank you, Chuck, for that same invitation to speak with you. I'm going to read a prepared statement. There's copies here. The House of Representatives voted to pass what is commonly referred to as the Justice and Policing Act of 2020. This letter details my opinions on some of the 134-page bill. There are many news articles that attempt to summarize the bill, as well as talking points that some would have you believe. To fully understand any proposed legislation, I chose to actually read the entire bill. I did it 3 times, actually, so I could fully understand it, since there is a possibility that some of it might become law. I chose to read the entire bill, not to trust a reporter's rendition or talking points from a political party. I would encourage this council and anybody watching to actually read the entire bill before you're making any decisions that will impact this community directly. While I won't address every aspect of the bill, that would require me to write about a 200-page dissertation. I am providing my opinion on parts of the bill that would be most detrimental to the citizens of our county, the safety of all police officers, troopers, and deputies, and the likelihood that qualified, intelligent police recruits will disappear from the landscape if this entire bill would become law. As you all know, there's already a severe shortage of applicants, both locally and nationally, for policing. Basically, the first 5 pages of the bill deal with definitions. Page 6 of the bill deals with holding police accountable in courts. That's what's in quotes. And it talks about revising Section 242 of Title 18 of the United States Code. Currently, the United States Code Section 242 reads, It makes it a crime for a person acting under color of any law to willfully deprive any person of a right or privilege protected under the Constitution or laws of the United States. For the purpose of Section 242, acts under color include any acts not only done by federal, state, or local officials within their lawful authority, but it also acts done beyond the bounds of that official's lawful authority. If the acts are done while the official is purporting to or pretending to act in the performance of his or her official duties, persons acting under the color of law within the meaning of this statute, including police officers, prison guards, and other law enforcement officials, as well as judges, care providers in public health facilities, and others who are acting as public officials. It is not necessary that the crime be motivated by animus towards race, color, religion, sex, handicap, financial status, or national origin of the victim. The offense is punishable by a range of imprisonment up to a term of life or the death penalty, depending on the circumstances of the crime. Thank you. What the law will change in the 2020 Police Justice and Policing Act, it'll change the term willfully to knowingly or with reckless disregard. I find it also interesting that I received an email yesterday from the title of it was Talbot Dems. And they say in their email, I guess to their membership, it was forwarded to me by one of their members who was concerned about the bill, about this meeting tonight, and then they stated in their email, the sheriff's strong statements on this piece of legislation are based on incorrect understanding. They go on to say the Justice in Policing Act would, 1, establish a national standard for police, 2, mandate data collection on police, which both are true, 3, reprogram existing funds to invest in the transformative community-based policing programs, which is true, this bill does address that, and 4, streamline federal laws to prosecute excessive force and establish independent prosecutions for police investigations, which is also true. But I honestly don't know who wrote the email, but I can only guess that they did not read the 134-page bill because they left out the part of taking qualified immunity away from local police, but not federal law enforcement officers, as the bill reads. You probably don't know this, but there's over 66 federal law enforcement agencies in the United States, and this bill does not address them in this as far as qualified immunity. It does not take their qualified immunity away, but it takes local police's qualified immunity away. Why is that? They also left out in the email that the possible sentence for violation of this section is death. It's the death penalty. And that's in Title 18, 242, that they modified with the word willful, and 3 sentences down, it talks about the death penalty. Again, I don't actually think any of our local friends read the entire bill, but are simply going political talking points for political expediency. I would assume that the Talbot Dems author had no idea that a sentence of death could be imposed. When will we as a community start thinking for ourselves and not blindly support bills that have an R or a D next to them, or a candidate that has an R or a D in front of their name? If I've been misunderstood, please help me know in an intelligent, well-researched way. In the handout that you'll be getting, if you don't have it, I highlighted the word willfully, because that's what they want to change in there. They didn't change death penalty, but they changed willfully. And right now, the law says that willfully, a police officer willfully would hurt somebody. In fact, you don't even have to kill anybody to be sentenced to death as a police officer now under the new Justice and Policing Act. A death only has to be associated with your action. So you don't even have to commit murder with this. So it would be the only case in which a law enforcement officer or a citizen of the United States, not under federal law but under state law, because you can be put to death for treason, but had not committed a murder that a police officer could be put to death for. The bill actually says, quote, "For the purposes of this section, an act shall be considered to be death resulting if the act was a substantial factor contributing to the death of the person." So even if the victim wasn't murdered, a police officer could be tried, convicted, and sentenced to die by lethal injection in a case where the victim wasn't actually murdered. Again, I find it also interesting that the same political party that claims not to support the death penalty actually does support the execution of police officers who violate these sections. If anybody here is a police officer or related to police officers, please stand for just a second and be acknowledged. So by supporting this bill, we conceivably would make it easier to put any one of these young men or young women, in that case, to death. Thank you. Ask yourself, would the legislation provide the impetus for more qualified police applicants to walk into the sheriff's office door? Would this provide greater security for our citizens and police officers? Page 6 deals with qualified immunity reform. I'm not going to read the whole section of qualified immunity. It's a bit lengthy. But the reformers want to amend that law by adding at the end of the law, "It shall not be a defense or immunity to any action brought under this section against a local law enforcement officer or a state correctional officer," as defined in this title. Which is pretty interesting when they do that. You go back to their definitions that we talked very briefly about earlier. But the law basically says the defendant was acting in good faith, believed reasonably or otherwise that his or her conduct was lawful at the time of the conduct was committed, or 2, the rights, privileges, or immunities secured by the Constitution and laws were not clearly established at the time of their deprivation by the law was otherwise such that the defendant could not reasonably have been expected to know whether his or her conduct was lawful. In order to really examine this part of the 134-page reform, we need to ask what the definition of local law enforcement officer is. Well, guess again, it doesn't include federal law enforcement officers, so they've exempted that. And they've exempted federal law enforcement officers from this. State correctional officers has no definition in their definition, so you can only assume that it's state correctional officers and it doesn't apply to your county detention officers, but it probably does, even though they never defined it in their bill. In their definition, local law enforcement officer means any officer, the agent, or employee of the state or unit of local government. So basically, it's your troopers, your police officers, and your deputies of the states and counties in the United States. I wonder why they didn't include federal law enforcement officers in this new law. Does the House think that the federal law enforcement officers are perfect? One can only guess, but by doing 5 minutes of research, you can quickly find that a union represents 26,000 of those federal law enforcement officers. And by all appearances on their website, they have a lobbyist in Washington, D.C. as well. If this bill was truly about police reform, why did they exempt them when it comes to qualified immunity? My guess is that they want their donations at re-election time. Do the federal law enforcement officers from time to time violate people's rights? A quick check of Google finds a number of cases that you can quickly find that federal law enforcement officers violated people's rights. We talked about the state correctional officers. Again, they're very well represented in one of the most powerful unions in the country. So they're not in there. Conveniently, they're not in there. Anyway, but back to the main point. The change of qualified immunity is probably one of the most damaging points in this bill, as it limits the rights of police officers to defend themselves in civil suits. As a quick reminder, the new law will not allow a police officer to use a defense that he or she was acting in good faith at the time his or her conduct, and I'm going to repeat it because it needs to be clear. As a quick reminder, the new law will not allow a police officer to use a defense that he or she was acting in good faith and that his or her conduct was lawful. Interesting to say the least. So to say an officer is being sued for, say, I'm going to give you an example, arresting a drunk driver who, after being handcuffed, headbutts the officer, which happens, and escapes custody and starts running away. The arrestee runs right into a path of a car and gets struck and killed. Under the new law, the officer being sued can't say in his or her defense that he was acting in good faith, that he was doing his job and he stopped the car legally, that he gave them the legal standardized field sobriety test, that he legally arrested him, that the officer was acting in good faith when the guy then headbutted him as a prisoner and ran away and got struck by a car. Does anybody on this council really believe that a police officer shouldn't be able to use that argument to keep from losing everything he or she worked for their whole life? Current law allows a citizen to sue a police officer, but it does not limit the officer in his or her defense. So you, as a citizen, can you make your own defense? So you, as a citizen, you can make your own defense, but a police officer is the only profession that's going to be limited in the defense they can have when they're being sued. In more simplistic terms, let's say Chuck Callahan builds a house and follows all Talbot County codes, building codes.
We hope.
Yeah, we hope so. A tornado comes through and destroys the home. The homeowner sues Chuck. If Chuck did, in fact, follow all the building codes, should he be able to say at his trial, I followed all the codes of Talbot County? If it were true, he should be able to say it as a part of his defense. Of course he should. Just like a police officer who acts in good faith and his or her conduct was lawful. But using the same example when Chuck's attorney brings up the fact that he followed all the building codes, the judge would have to stop him, his attorney, and say, you cannot tell the jury that. And you can't use that as a defense. Will this help policing in the United States or here in Talbot County? It will certainly help attorneys, as there'll be more and more lawsuits will be filed, and we know that Congress is made up mostly of attorneys. But will this actually help our citizens to be safer? I don't think so. Police will stop all proactive policing. They will stop traffic. Traffic stops will drop dramatically. Deaths on the highways will rise. Drugged and drunk driving arrests will drop. Even more deaths. Violent drug trafficking organizations will flourish. Those investigations will drop. Just take a look at Baltimore City. Arrests since the riots 4 years ago are down more than 80% in the city. Violent crime has risen dramatically, and the homicide rate is through the roof in Baltimore City. Just in the last 3 weeks, New York, shootings are up 600% over the same time period last year, over a 3-week period this year. 600%. I'm not going to bore you with the rest of the 100 or so pages, but these are my thoughts on what I think are the most important things that need to come out of that bill. You know, you have the $1.9 million budget modification that I submitted, because that's what it would cost, between about $1.2 and $1.9 million in Talbot County if that bill passed in its entirety. Basically, we would have deputies and police officers in training 2.5 to 3 months a year. So we would have to hire more deputies, and you can read through the budget modification, to come in compliance with that proposed legislation. Where's that money going to come from? Schools, roads, parks and rec? I would encourage you to reconsider the letter of support, then draft a letter and ask the House and Senate to actually work together. 70% of their bill and 70% of the bill with the R behind it are very similar. I'd be glad to, and I have sent it to some of you, some of the national police reforms that I believe should happen. And I've sent this to some of you, maybe I've sent it to all of you, but if not, I'll resend it. But make them work together. Tell them to do their jobs, work together, and hammer out a fair bill that will keep our entire community safe, our troopers, police officers, deputies, while holding the criminals accountable for the crime they commit. I don't know what their motivation was behind this bill, and I don't want to sit here and guess, because, you know, I'll be criticized for that. But I truly think, I don't even know if they ever want to agree on anything up there, because obviously they haven't tried to agree on anything. But Senator Scott's bill and this bill, about 60 to 70% of it is very similar. If they would sit down, and that's the letter you send, is encourage them to sit down and stop playing stupid games and do their freaking jobs. I'd be glad to answer any questions.
Well, Sheriff, I want to thank you for coming and giving your well-thought-out response.
Thank you.
And I want to say to you personally, of course, my comments were not directed at you personally at all. We certainly value in what you do here in this county. But we certainly want to thank you for coming and giving your comment, and thank you for sending the information to us as well regarding budget modifications and your perspective on ongoing national police reform. So
Thank you,
I do
President
appreciate it.
Pack. I
Thank you.
appreciate your time.
Well,
Thank you.
Counsel, I do have my comments on the matter that I want to read to you as well.
You want me to stay here, or you want me back?
You can have to see, oh, watch yourself.
I'll just spill some water on it.
No, so we get that, we'll get that.
While you're getting organized, I just want to say that I'm happy to have been the one who knew that this was a bad idea. I don't pretend to know that I did not read the entire bill, but I did know enough that the vast majority of the Senate and the House versions did overlap. I follow the news and all of that, and so for you to just say that, again, that 60 to 70% of the bill, that's exactly what I said 3 weeks ago, and that we needed to let them work it out. And that's what I suggested 3 weeks ago. Let's let them work it out in Washington, and then we'll come back and we'll support a bill. That's exactly what I said 3 weeks ago, and I'm, glad that's what you just said, because my gut was telling me that. My gut was telling me that, and sometimes you have to listen to that. So thank you for everything you do. I have always had the backs of our law enforcement and our paramedics and, all the county staff. But you guys are, it is the priority, and it always has been, and I trust you. So thank you very much.
Okay, I'll be brief with my statements. It's not that much. The comments I'm about to deliver are directed to those members of the County Council who voted in the affirmative on June 23rd legislative meeting for a letter to be sent to our federal delegation seeking their support for H.R. 7120, the Justice and Policing Act of 2020. As it pleased me initially to have your support for a national bill seeking police reform, it has come to my attention that several of the affirming members are now reconsidering your position on the matter. Before casting your vote on reconsideration of the letter, I would like to take a few moments to speak to you as to why national police reform is so important to me as it is to many other persons of color in America. I would always like to express to each of you my sincere apology if at any time during the June 23rd meeting my words offended you. It was not my intention to make any of you feel pressured or coerced into casting your vote. My words may have been delivered in a forceful manner, but in no time was I attempting to belittle or shame you to casting your vote for national police reform. I mean that sincerely. I had made my intentions clear to the Council and to the public during the June 9th meeting of my desire for a joint letter of support for H.R. 7120. Right or wrong, I assumed that prior to the June 23rd meeting, that members of the Council would review the legislation and be prepared to discuss the merits of the act. During the conversation surrounding the letter, it was suggested that Council seek the input of the sheriff prior to issuing the letter. My reaction to the suggestion was not an attempt to diminish the advice of the sheriff, but my reaction stemmed from my feeling that members of the Council did not understand the pains that persons of color had been subjected to at the hands of individuals sworn to protect them. If you recall in my address to Council on June 9th, I praised the sheriff for his actions here in Talbot County in recruiting people of color. His hiring of Deputy Bryant Ortez, the first Spanish-speaking officer in the department's history. My statement was not meant to diminish the role of the sheriff or the state's attorney. On the contrary, I consider them both an invaluable part of this county. If you may recall, during the March 10th council meeting, a majority voted to send a letter of support to a proposed amendment under HB 1300, the blueprint for Maryland's future. This legislation, as you know, deals with funding for Maryland schools. The Council's letter of support was affirmed without any input or consultation from the school superintendent. I'm sure that those affirming members of the Council were not showing any disrespect to the superintendent when casting their vote. My support for national police reform is not an emotional reaction or my yielding to the chants of protesters. My support is based on documented accounts of unarmed persons of color being killed by uniformed officers that has been happening with increased frequency, in my opinion. My support for police reform is based on my concern for the safety of my 30-year-old son living in Atlanta, my brothers living in Oklahoma, Pennsylvania, and Texas, and other family and friends who do not reside in Maryland but in states where police accountability and oversight are not as controlled and regulated as they are here in Maryland. My support for police reform is based on my desire to see the elimination of the use of chokeholds on citizens of any color. My support for police reform is to improve training on racial, religious, and discriminatory profiling by law enforcement. My support for police reform is for the establishment of a national police misconduct registry to root out individuals who are unfit to serve. My support for police reform is for the creation of local commissions or task force to help communities develop just and equitable public safety approaches. My support for police reform is to see mandatory use of force reporting for all police agencies across the nation. My support for police reform is to see neighborhoods and law enforcement work together to deal with those who perpetrate criminal behavior. My support for police reform is for the mandatory administrative leave for any police officer involved in the death of a citizen, for the officer's mental health well-being, as well as for the healing of that community. But Councilman, if your vote for H.R. 7120 was not out of a genuine concern for social reform, then I respectfully ask for you to reconsider. And Councilman, if your vote for H.R. 7120 was not based on your understanding of the legislation, I again respectfully ask that you reconsider. And Councilman, if your vote for support of H.R. 7120 was out of fear of being labeled intolerant or racially insensitive, I again respectfully ask that you could reconsider your vote. And if your support for H.R. 7120 was a show of respect for me, as humbling as that may be, I would again ask that you reconsider your vote. Concerning H.R. 7120, it has been, excuse me, it has been approved by the U.S. House of Representatives, and the legislation is now being sent to the U.S. Senate, where its future is uncertain. Here in Maryland, the state legislature has convened a work group on police reform focused on accountability and transparency. I am sure that we can expect them to propose police reform legislation for the upcoming legislative session. Should this occur, it is my hope that this council, as well as the Maryland Association of Counties, will take an active role in the creation and the implementation of statewide police reform. Councilman, leadership requires courage, and courage comes from our moral convictions and our moral center that binds us together and shapes our communities. When we know that something is right, something isn't right, it is our moral responsibility not just to speak up, but to do what we can to fix it. So in closing, perhaps we need to develop more consistency when we are asked or are considering sending a letter regarding any pending state or federal legislations. I would again wish to apologize to any member of the council who may have been offended by my actions. Yet with or without the support letter for H.R. 7120, I personally will continue working even across party lines, if necessary, to see that national police reform in America becomes a reality. This is too important of an issue, and I will not and cannot stay silent when I know that we can be a better nation. I cannot and will not be silenced by fear or intimidation when I know that communities of color depend and rely on trustworthy and faithful community police officers. And that would be my statement on the matter. So if there are not any additional comments, Mr. Lesher, I believe your motion was seconded by Mr. Callahan. Is that correct? Okay. Madam Secretary, on the motion to reconsider, would you please call the roll?
So explain the ayes and the nays on this one with the vote. If you vote aye, it means you're reconsidering not to send, and we won't be sending the letter.
Right.
Is that correct?
I vote will mean you're supporting the motion to reconsider not sending the letter.
Got it.
Okay. All right.
Mr.
I'll abstain from the vote.
Mr. Callahan?
Aye.
Ms. Price?
Aye.
Mr. Lesher?
Aye.
Do we have Mr. DeVillio's vote?
We do.
Okay.
Mr. DeVillio votes aye.
Okay. So the letter, it is already in the public domain, as we know, but nothing official will go forward. We'll go back to where we were, last week before the motion was even made to consider. Again, gentlemen, thank you very much. We appreciate all that you do. And Sheriff, we probably will be talking in the future as we hopefully try to prepare what they're going to do in the state senate regarding this.
Well, George, thank you very
Okay,
much for
thank
your
you.
consideration.
Council, next on your agenda, you have introduction of a resolution. And Madam Secretary, if you all want to wait for a moment. Madam Secretary, would you read the resolution, please?
An administrative resolution of the County Council for Talbot County, Maryland, requiring the development of a Talbot County diversity statement, providing for the inclusion of such statement in the county employee handbook, and requiring a written acknowledgement from each county employee and board, commission, and committee member that they have received, read, and understand the diversity statement.
Thank you very much, Madam Secretary. I had offered this resolution up to council at our last meeting. I had made mention of it back in our June 9th meeting that I would ask for consideration of this. I think that the creation of a diversity statement would speak volume to this county as far as who we are and what we stand for, and to make sure that persons who are hired by us understand that we are a county that supports diversity of all types, as well as on our boards and commissions, that they would also, and I think this was that Mr. Villio's urging, that they would also have to sign that they have read and understand what the diversity statement is. So the matter is now before council for, I guess, reintroduction since it was introduced last week. And
In council, I'd like to be on the record again fully supporting the development and inclusion of the diversity statement in the county handbook as I was last meeting.
thank you very much for your support, Mr. Hollis. Okay, Chair would now entertain a motion for the administrative resolution on diversity, or
So
diversity
moved.
statement, moved by Mr. Callahan,
Second.
seconded by Mr. Lesher. And the chair would open the floor for any comment.
Yes, I'd like to talk, Mr. President.
Sure.
I just want to talk about the diversity statement and what we talked about last time. I was not feeling that I knew enough about it.
Okay?
I felt like I wasn't ready to vote on it. Now that I've touched base with the county manager and HR, I feel very confident that we are headed in the right direction. I understand where we need to be at now. So I feel very confident that HR and the county manager, and we have a team and a communication now. I felt like the communication wasn't quite there.
Okay.
So now that I know the communication is there between HR and the council and the manager, everybody's on board on what we want to do. So I'd like to have better communication next time with everybody understanding what we're voting on, and that way we won't run into this problem again.
That is so crucial that we communicate and understand. Mr. Lesher, any comment from you?
Look, this is simply a best practice in workplaces today. And to quote from a guide for this, minorities and majority-run organizations more frequently experience gaps in understanding expectations and receiving constructive feedback, while also disproportionately lacking mentors or trusted supporters who will share the unwritten rules for success. Talbot County should simply align with leading workplaces elsewhere and develop such a policy. So I support this.
Any further comment before I call for the
Yep.
vote?
Yes. Certainly, we talked about diversity and inclusion, meaning people of different educational backgrounds, levels of experience, females, minorities, veterans, and people with disabilities. I've always supported the county's commitment to I've always supported the county's commitment to diversity in our workforce, and I believe our commitment is evident in the relationships that we enjoy among all citizens in our county. Reinforcing this commitment to diversity, including it in our employee handbook, is consistent with our current employee code of conduct. I do believe that asking our county manager and director of human services to gather some language from other localities throughout the country for a statement is a really good starting point and an efficient beginning. I thank our HR director and our county manager for doing this research, and I'm encouraged that we are headed in the right direction.
Very good. Thank you, Mrs. Price. There's no further comment. Madam Secretary, will you please call the vote on the administrative resolution for diversity statement?
Mr. Pack?
Aye.
The administrative resolution was never actually introduced last time.
I thought we
You
just-
amended the wording to include board, commission, and committee member, but it was never actually
So the
introduced.
amendment was introduced, and
Yes.
So we gotta
so
reintroduce
I
it.
just asked Mr. Callahan for it. Okay. I need a vote for introduction. I apologize.
Yep.
Mr. Callahan
So moved.
for introduction.
Second.
We did that.
Now the vote?
Now we
Okay.
can vote.
Okay.
I thought we just did that. Okay, I'm
Yeah, we
having a little deja vu. So I thought we just took a vote before. Okay. All right, now would you please call the vote on the resolution as introduced?
Mr. Pack?
Aye.
Mr. Callahan?
Aye.
Ms. Price?
Aye.
Mr. Lesher?
Aye.
And Mr. Villio?
Mr. DeVillio votes aye.
Okay, thank you very much, council, and this is a great day for Talbot County as we move forward and working together, understanding each other, and communicating. So thank you very much for your vote. We're about 15 minutes late, but that's no big deal. Our public hearing is now about to undergo. We'll ask anyone who's here to speak on Resolution 298 that was dealing with term limits. As the sole sponsor of that, I am asking council to table that, so that will not be considered this evening. We have several items on the agenda here for public hearing. What I'm going to do is have Madam Secretary read each of the items for public hearing, bill number, then title, and when you come up, please give us your name. Let me just say for the record that I will no longer be asking for your address when you come to give testimony. I find that a bit unnecessary under the current climate that we're in. And speaking with the Office of Law, there's no legal bearings why we need to ask for your address. So whether you're a resident here in Talbot County, or you come here recreationally, or you work here 9, 12 hours a day, but you lay your head down in Queen Anne or Caroline County, you are welcome. You are welcome to give testimony to this council on matters related to this council. So your citizen, your residency here, or not here, will not preclude you from giving that comment. So I will no longer ask for your address.
Mr. Pack?
So,
Since we have the long list, there are a whole bunch that really are the capital ones. So my suggestion would be to do Bill 1447 as a standalone, and then maybe do all of the capital projects, which is item 7.
yeah, that's what I was going to go, Ms. Price. And other than 1446, which we will not be taking action on tonight. So,
But the 1447 is the liquor license
Right.
commissioners. That's really separate than a capital item. Can we hold that one separate and then do all the capitals together?
is Ms. Lane here? Oh, that's you, okay, all right. Yeah, we can do that. I'll separate that one out as well.
Mr.
I
Pack,
didn't see her back there behind Mr. Howard.
could you make sure that everybody heard?
Yes, thank
Yeah,
you very much.
Yeah.
Thank you very much, Ms. Collins.
And there's
I
a-
just,
I'm sorry, there's one other that is the definition of single-family detached dwelling. So I guess what I'm suggesting is.
1463, okay.
Yeah, so C, 1448, all the way through P, 1461 should be one public hearing.
Right,
and the
those are all the
rest-
capital, okay, we'll bind all those together and just
Okay.
pull out the other three. That will work. Just for your, but just also for public record, Bill 1446, which is dealing with the short-term rental, will not be taken on tonight for vote, where this is just a public hearing. We will not be voting on 1446 tonight. We're just taking public comment on that tonight. So just want to make you aware that if you want to give your comment and leave, you're not going to miss anything because we're not going to be voting on 1446 tonight, okay? So as the instruction is, Madam Secretary, if you would, well, you can read all the bills, but we're going to be taking some of these and pulling them out. But what I'll have her do is read all the bills that we're going to be going through tonight for public hearing by bill number and by title, and then we're going to segregate some of these bills out separately to have the public hearing on them, okay? Don't worry, Mr. Hollis, I got it straight.
Bill number 1447, A bill to amend Chapter 11 of the Talbot County Code, alcoholic beverages, to allow the Board of Liquor License Commissioners to issue a license for on-premises consumption of beer to Class 5 breweries and allow for local licensure for Class 6 pub breweries and Class 7 microbreweries.
Okay, let me stop you right there. Is anyone here to speak on Bill 1447? Anyone here to speak on 1447? Have we heard from Ms.,
Yes.
have we heard from Zach?
So, Mr. Pack, we do have some callers. I think Ms. Morrison's going to...
Mr. Pack, we do have several people attending the meeting. Mr. Zach Smith is not one of
That's
the
what I was looking for.
identified people on. However, I will announce if you are on the WebEx this evening and you do wish to speak, if you could send me a message if you're participating through the WebEx computer portal and give me your name and which bills you'd wish to speak on. We can identify you by that way. Otherwise, I can open it up to the 7 unidentified call-in users who may be wishing to speak.
Did you say that Mr. Smith was already identified as one of the callers?
He is not
He is not, you see,
identified.
it's not identified.
Right.
Okay.
He could be one of the unidentified callers.
Well, why don't you find out if anyone there wants to speak on 1447 before we move on?
Okay. I am unmuting the call-in users. If you are on the phone and you wish to speak on bill number 1447 concerning Class 7 microbreweries, the line is now open. Okay, could you hold for just a moment, Mr. Moritz? Can everybody hear? This is Adrian Moritz.
Can you bring the volume up on that just a tad bit, please?
Mr. Moritz, the floor is open. Could you speak up a little bit? We're going to try and adjust the volume. Go ahead.
Yeah, I'm one of the owners of the Disbursements, and we are 100% support of Bill 1447.
Can't hear.
Mr. Moritz is saying that he is in support of
Yeah.
Bill number 1447.
Thank you for calling in, Ms. Moritz. Anyone else on Bill 1447?
Yes, sir. Could you please identify yourself by name?
Oh, there's Zach, okay.
Can you
Hi,
put that
Mr.
by your microphone? I certainly cannot hear that. I don't know.
Mr. Smith, could you go ahead and speak? We're going to try and adjust the volume.
Zach, we're going to boost your volume up here. If you just give us just one moment. Thank you for calling in. We're certainly anxious to hear your comments, but we want to make sure that we have the audio at a level where everyone can hear comfortably. So if you just give us one moment here, we do apologize for the delay. Okay, thank you, Zach.
Why are people here? There's room.
Zach, why don't you go ahead and give us a sound check, please? Yeah, I can hear you a bit. We'll try to boost it a little bit more, but just... There you go. Thank you, Zach. Go ahead, please.
Okay, sure. Thank you, Brother. Council, I'm sorry I can't be there in person to speak, but nonetheless, Zach Smith, on behalf of East Central Brewing, I greatly appreciate the council's willingness to consider proposed legislation for East Central. As the council knows, this legislation was introduced at the request of East Central Brewing, essentially to permit the maintaining the status quo of its operations. As we discussed, East Central Brewing was started back in 2008. At that time, the brewery had obtained a license from the state of Maryland, Class 5 brewery license. And it started Charlotte County at that time to ask if a local license they needed. East Central Brewing was told at that time that local license was not needed because the brewery was already regulated by the state. current changes to state law and current operations being approved, although those are like what was called on-site permits are now technically required. Keep the short-term rental wants to follow the law.
Are you still here?
And obtaining
Are you still hearing?
sorry.
This is not going to work for the night.
Continue on, Zach, we can hear you.
Okay. Eastern Shore Brewing doesn't want to follow the law and obtain the required permit. What the permit is not currently provided for in the county code. And so this proposed legislation as it relates to brewery will simply create a local permit and authorize the local county liquor board to issue such to the holder of the Class 5 brewery that is licensed from the state of Maryland. This change will only impact licensed breweries, and I believe Eastern Shore Brewing is currently the only licensed brewery in the town, in Talbot County. This legislation is consistent with what other county councils in Maryland have enacted to support their local breweries. I believe this legislation essentially mirrors similar provisions in the federal county code and is similar to other counties as well. And importantly, the adoption of this legislation is frankly necessary to allow Eastern Shore Brewing to continue its operations and really just to maintain the status quo. And so it's very important to us, and we urge the council to support the bill. And again, thank you very much for your consideration.
Thank you very much, Zach. Anyone else on the call for comment on 1447? Okay. Again, is there anyone here on 1447, just to make sure? Okay, thank you very much. Madam Secretary, would you continue reading the enabling bills by number and title, please?
Mr. Pack, are we going to act?
I was going to go through all and come back, but
And then-
You
yeah.
want to just take care of that one, vote on that one, so we don't get confused at all?
I'm not going to get confused. I'm not going to get confused. Okay. So we have at least 10 enabling legislations here, so why don't we just go ahead and read those by number and name, title, please.
Bill number 1448, a bill to amend Bill number 1366, the appropriation for improvements to Black Dog Alley. Bill number 1449, a bill to authorize the replacement of the Easton High School football track. Bill number 1450, a bill to authorize a nutrient credit program. Bill number 1451, a bill to authorize the purchase of additional security cameras for the St. Michael's High School. Bill number 1452, a bill to amend Bill number 1393, the appropriation for the development of the Frederick Douglass Park on the Tuckahoe located at 13213 Lewistown Road, Queen Anne, Maryland. Bill number 1453, a bill to amend Bill number 1404, the appropriation for a sewer system for the Ferry Point Marina and surrounding areas. Bill number 1454, a bill to amend Bill number 1430 and Bill number 1362, the appropriation for the Region 2 St. Michael's Sewer Rehabilitation and Improvements. Bill number 1455, a bill to authorize the purchase and installation of a new telephone and public address system for the White Marsh Elementary School. Bill number 1456, a bill to amend Bill number 1420, the appropriation for the renovation of classrooms at the Easton Elementary School Dobson Building for the Early Head Start program. Bill number 1457, a bill to amend Bill number 1422, Bill number 1335, and Bill number 1317, the appropriation for stormwater management and upgrades of Goldsboro Neck Road and Airport Road. Bill number 1458, a bill to authorize improvements to Skipton Creek Landing Boat Ramp. Bill number 1459, a bill to authorize the resurfacing, repaving of the Easton High School parking lot. Bill number 1460, a bill to authorize a gymnasium addition to the Talbot County Community Center. And Bill number 1461, a bill to authorize the resurfacing, repaving of the St. Michael's School parking lot.
Thank you very much, Madam Secretary. These are our enabling bills. There will be no money spent on these bills at this time if they should pass this evening. These just allow council to have these items approved for further action to be taken down the road.
After the public hearing portion, I would like to pull Bill 1450 out, the nutrient credit program, because that just kind of got lumped in, and it doesn't seem really the same thing as voting on the high school track and some of those other things, and I really
No,
definitely a lot more. Yep.
it was introduced as part of the enabling legislation. This was handled by.
I'm asking that I want some more information I'd like to have, whether that's Mr. Clark or somebody come in and address that further. I'm just saying.
Mr. Clark unfortunately had a family emergency
I
and couldn't be
understand,
with
not
us this
tonight.
evening.
I'm just saying,
Okay.
I'm going to ask that that would not be voted on, number 1450, not voted on this evening, and keep the rest of them if you want to gather.
I've also had several watermen reach out to me that this is not a good bill.
This is not a good bill.
Yeah, that's, I had, yes. Mhm. Yeah, apparently, it's, it has to do with the oysters. You're allowed a certain oyster, and you can't do wild oysters. So it should be some of the watermen in front of us explaining this.
Are you sure they're talking about 1450? This is a nutrient management bill. This allows you to have nutrient credits.
It's a trading program, so anyway, I just would like to, we
Yeah,
had a public hearing, but I'd
yeah.
like to push this to the next meeting
So
for a vote.
we probably need some more information
Yeah.
on that. Yep.
Well, again, Mr. Clark unfortunately could not
Yep.
be here with us
okay.
on that.
That's fine.
Next week.
To give his comments on it. So, the floor is now open for any public comment on these bills regarding the enabling legislation. Anyone wish to give comment? If you give us your name and the bill number that you want to comment on. Any other callers want to comment on any of the bills? Mrs. Morris.
Nobody has written in that there are any bills that they would like to comment on. I can open it up to the call-in users again to see if anybody wishes to
We don't want
speak.
to,
I'm currently unmuting any of the call-in users to see if they wish to make any of the comments on what we are calling our capital enabling bills, which were just read into the record. If you do wish to speak, could you please identify yourself by name? Again, the floor is open for any of the call-in users to tonight's Talbot County Council meeting if you wish to make any comments on the capital enabling bills, which were just read into the record.
no?
No comments.
Okay, let's move forward. Next bill to be introduced for public hearing is Bill 1463.
Bill number 1463, a bill to amend Article 3 of Chapter 4 of the Talbot County Code, Development Impact Fees, to add new definitions for single-family detached dwelling and other residential.
Thank you very much, Madam Secretary. Anyone wish to speak on Bill 1463? Okay, any callers wish to speak on Bill 1463?
Callers, if you would like to speak on bill number 1463, could you please identify yourself by name? The floor is open.
No? Okay. And Mr. Salinas, thank you for being with us this evening. Do you have any comments on Bill 1463? We would just have public, we're about to move on with it, but since you're here, didn't know whether you wanted to give a brief comment on the bill.
I do. Thank you, Mr. Pack, and good evening, members of the council. Just in preparation of the public hearing, I just wanted to briefly just go over, because we've been discussing changes to the SCR regulations, which have led to this draft of this bill 1446 since August of last year. So I just wanted to briefly remind the council of the process.
1463.
I'm sorry, this is 1463? I'm sorry. This is the
Single-family detached?
impact fees. No, I don't have any comment then, I'm sorry.
But you might as well stay there. 'Cause no, don't leave, because you just have one bill ahead of me. Okay. Brent, good to see you. Do you have any comments on 1463?
No, sir,
Okay.
other than what we changes we've shown.
Okay. Mike, how are you doing?
Good.
Okay. Anyone from staff on the bill? Just want to make sure. Okay.
But 1463 is just a change to the definitions. It doesn't change anything in our zoning code.
It doesn't.
I can address it
Well, it
briefly.
will allow them to now get there.
So really all it does is, like you said, Ms. Price, it changes the definition. This is in the development impact fee ordinance. And so this carves out a slightly more specific definition related to certain types of residential dwellings. And we have two different types of residential dwellings pursuant to this bill, and they're different types of development impact fees depending on which one you qualify as. So I think you're going to get a lower development impact fee under this bill if you're building multiple small houses on a single lot, and that would be a type of affordable housing potentially. So this would have the net effect, hopefully, of encouraging some affordable housing, workforce housing in the county.
Okay. Thank you. And our last matter for public hearing tonight will be Bill 14.
Mr. Pack, just a quick follow-up question to that.
Sure.
The Planning Commission has not weighed in on this particular bill, is that correct?
I'll ask Mr. Salinas to.
That is correct.
Is that because the nature of this is more financial than land use planning impacts?
Yeah, I believe under Chapter 190, the Planning Commission weighs in on amendments to the text for that chapter, which is our zoning, land development, and subdivision ordinance. But this impact fee legislation is a different chapter of the Talbot County Code, and so that's why the Planning Commission, this doesn't get referred to the Planning Commission for review and recommendation.
I know, of course, this would only, the collection of these impact fees would only affect new construction going forward. But do we have any examples of this type of development currently that, if it were to be built now, would be subject to, or would get relief from this particular legislation?
There is a development that has been constructed or partially constructed. If you go past where the Department of Corrections is, there is a large lot back there where there have been several of these smaller single-family houses that have been built. I don't know if they're finished with that project, but that's, if they have not finished and this bill becomes effective, then when they go to get a building permit for any of the remaining units, I think they could probably take advantage of this. And then if they're planning on doing any other developments like that.
Yeah, that is correct. None other than the one that Mr. Cooper Smith referenced.
And simply because the development occurs in a town as opposed to the unincorporated area, developments that occur within the municipalities still are charged a county development impact fee. So they can take advantage of this legislation even if it's occurring within a town.
And we collect that because of the impact on schools, on road infrastructure, and obviously the town doesn't have any school costs. Those are borne by the county, and therefore
Right.
It's appropriate for us to collect impact fee counties for schools from in-town developments.
That's correct. The development impact fees that we have on the books now were the product of an extensive study by a outside consultant who calculated all of the various costs that an average development would have on the various county services. And so that's where we have the fees. They're drawn from that study. And even if it occurs within a town, you're still going to have an impact on county services. The towns have their own development impact fees as well that affect their services.
And is it the presumption under this that because these are smaller units, that each individual unit, if charged for individual impact fees, that would be a disproportionate burden out beyond the sort of, the
Yes.
same is collected from one of these small units as from a 3,500, 4,500 square foot house?
Yes.
And therefore, this is proportional. We presume that since these are very small units, one bedroom at most or something like that, they're not going to put as many students into the schools or as many cars on the roads or as many of the other impacts that we collect fees for.
Right. It's a more refined approach. Yeah.
Mr. Lesher, I just want to comment on so you understand, for the record, I am the one that's doing the workforce housing down the road that Tony is talking about. So I am building, so far I've built 5, and they're called tiny houses. They're about 720 square feet.
Yeah.
Okay?
I
So
remember when these
right,
were
so,
approved.
I'm doing that project.
The tiny houses I've seen on HGTV are not 700 feet.
I know,
like
they're
200
like 200. So I really, want to comment too on, I appreciate you asking and clarifying that stuff so people understand what we're doing. But the ultimate goal is for the developer to give relief so we can get what we've always tried to do here with workforce housing and give them somewhat of a break and an incentive to do these homes. You know what I mean? Because they're 2 bedrooms. They're 2 bedrooms, 2 bedrooms, 1 bath.
So back to Mr. Lusher's first question, he asked if the planning commission had weighed in yet.
Excuse me, Mary Kay is participating by phone, and she does have a comment that she'd like to make.
Awesome.
Mary Kay, I believe I've unmuted you, if you'd like to go ahead and speak.
No.
Yes.
No, I
Go
can't.
ahead.
We're here, Mary Kay, go ahead. We'll try to boost your volume, go ahead.
This is for residential units on a single parcel of land where they have multiple units. Typically, those units are in a townhouse or apartment. So those are residential units get a reduction in the overall impact fee of approximately $2,000 over a single family detached unit. This will allow when we're having multiple single family homes on a single parcel that are each less than 12 square feet to take advantage of the reduced impact fee. And as Miguel has stated, obviously it's not required to make a recommendation on this particular section.
I gotta be honest with you, I'm missing every other word she's saying, so this is not helpful.
Counsel, I think I understand what she was trying to say. at least
Okay.
some part of it.
Thank you.
Ms. Lane is going to try to summarize your statement, Mrs. Verdi. Thank you for joining us by phone. Just hold on for one moment there.
It's garbly.
With the development impact fee legislation, there are fees for single-family homes, and then there is another set of fees for multifamily homes, which is normally townhomes or duplexes, which are lower. And I think what Ms. Verdery was trying to say is that this is trying to do the same thing that we do for the townhome situation for the single-family homes, because they're a smaller home on a single lot, to reduce their fees so each house doesn't pay as high a fee. And this structure will get those type situations in line with the townhome situation, which we currently have in the legislation. And the other item she addressed was that the Planning Commission does not review this because it is in the taxation section of the code, not under the planning and zoning land use section of the code. I think that was what.
I remember when this first came up and brought to my attention, as you just said, Mrs. Lane, that single-family dwellings did not get the reduction in impact fees. Only those townhomes or apartments would get that reduction. And there was nothing in our code to allow for single-family homes to receive that reduction in impact fees. So you're right, this 700 square foot house is paying comparable to what's 300,000 square foot house would be paying. So this would make it even playing field. It will allow those small workforce units to be built on one lot and to receive the reduction in impact fees the same as if you were in a 700 square foot apartment. You know, it's just trying to make it fair for those builders who are building single-family structures and not townhomes or duplexes.
But, Mr. President, I think if we could, since Mr. DeVillio is not here this week, could we hold off until the next meeting, so he's here and understands what we're doing. You know, I'm a little bit,
Well, he didn't ask for this one to be set aside. He did ask for 1446 to be held.
I'm just a little sensitive because, you know, I am involved in that project.
You want to recuse yourself?
I'd like to, yes, yeah, you know, so,
Well,
you
he
know.
did leave a vote.
Okay, that's fine, okay. Yeah, if he did leave a vote, that's fine. Yeah, okay.
So you will be recusing yourself?
Yeah, I think I should, yeah.
I think you should.
Yep.
Any other questions on 1463? I think between Miguel and Ms. Verdery and Ms. Lane, and
Yeah.
I think we got a good
I
team
think,
there.
yep.
All right, so we've had all the public hearings except for the short-term rental, which we're not going to vote on. Can we go ahead and take care of the votes on the ones that we're going to, and then, so that we can clear our minds and listen to the short-term rentals?
Okay, let's work our way backwards if we could then. The most recent matter, so people won't forget what we just talked about, is 1463. The chair would entertain a motion to move that to third reader tonight.
So moved.
Moved by Mrs.
Second.
Price. Second by Mr. Callahan. Any question on the motion to move the third reader on 1463? Hearing none, Madam Secretary, would you please read the bill a third time?
Bill number 1463.
I ask that so much be considered a reading.
Any objection? Hearing none, 1463 is now before the council for final vote. Thank you very much for procedurally that.
I will
So
second.
Mr. Callahan cannot get a second. Second is made by Mr. Lesher. Thank you very much.
Mr. Pack, I'm sorry to interrupt. Ms. Morris has pointed out that we have not gotten public comment on that bill.
Oh,
You didn't? I thought
We
nobody
didn't
was on the
ask.
call.
We brought Miguel up. and then we got
You're right.
distracted by the
Miguel
call.
came up, but then we didn't go to pub, so I'm going to have to pull back those motions at the time. Do we have any callers on the phone for 1463?
Callers, we are opening the line. If anybody wishes to speak on bill number 1463, could you please identify yourself by name? The floor is open.
Okay, thank you. So we'll go ahead and close that on 1463. I got confused with Ms. Verdery calling in, whether she was a caller or not, so. Okay, so,
motion to.
motion's made by Mrs. Price to go ahead and move 1463 to third reader. Procedurally, it had to be seconded by Mr. Lesher. Bill 1463 is now before the council for third reader. Madam Secretary, would you please read the bill?
The bill to amend.
I ask that so much be considered a reading.
Okay, any objection to Mrs. Price's motion? Hearing none, 1463 is now before the council for final vote. Any comment on 1463 before we go to final vote? My only comment would be I want to thank Ms. Verdery and Mr. Salinas for their work on this. There was a lot of input from a local builder regarding whether or not small single-family dwellings could get the tax credit or the impact fee credit that apartments and duplexes got here in the county. I thought that that was reasonable, that the smaller units would serve the same purpose to allow workforce persons to live in those small units and to contribute to the community, that they should be treated as the apartments are treated in the reduction of impact fees. So again, just want to thank staff for their work on that and thank the local builders for giving their input on the drafting of this bill. With that being said, if there's no further comment on 1463, Madam Secretary, please call your roll.
Mr. Pack?
Aye.
Mr. Callahan?
Abstain.
Okay.
Ms. Price?
Aye.
Mr. Lesher?
Aye.
Mr. DeVillio?
Mr. DeVillio votes aye.
Okay, 1463 passed with one abstention. Madam Secretary, we're going to take the enabling legislations all together with the exception of 1450. There was a request to hold that off for the next council meeting. So in the matter of 1448, 1449, 1451, 1452, 1453, 1454, 1455, 1456, 1457, 1458, 1459, 1460, and 1461. The chair would ask for a motion to move those to third reader.
So moved.
Moved by Mr. Callahan,
I'll second.
seconded by Mr. Lesher. Any comment on the motion to move the third reader? Hearing none, Madam Secretary, on the motion to move the third reader, would you please call your roll?
Mr. Pack?
Aye.
Mr. Callahan?
Aye.
Ms. Price?
Aye.
Mr. Lesher?
Aye.
Okay, those matters, I'm not going to read those bills again. I read it for the record. Those bills are now before the council for third reader. Madam Secretary, I hate to do this to you. Would you please read those bills?
Bill number 1448.
I ask that so much be considered a reading.
Any objection? So we won't have to do this 15 times. Is there any objection to the Mrs. Price's motion being considered for all of the bills I just read? So, no?
I
Okay.
ask that so much be considered a reading of all of those bills.
Thank you very much. Any
Okay.
objection to that? Okay, rather than have the secretary read those again. So all the bills I just read are now before the council for final vote, with the exception of 1450, which I did not read. Okay. Any further comment?
The only comment that I would make on these right now is this is capital enabling legislation. We have no idea where our money and our revenues are going to end up. This does not give a final say-so on these projects. As these projects come up and we have a better handle on where our revenues are coming in, we may not be able to do all of these. And I hope that the council will obviously think about that as we get further information throughout the fiscal year. So I just wanted to say that I have some trepidation about a few of these, but since we're not actually voting to spend money tonight, I'm comfortable at the moment.
Any further comment? Okay. Madam Secretary, will you please call the roll?
Mr. Pack?
Aye.
Mr. Callahan?
Aye.
Ms. Price?
Aye.
Mr. Lesher?
Aye.
Mr. DeVillio?
Mr. DeVillio's left ballots. I'm just going to go through the
Please.
different bills, just for clarity for the
Thank
record. Mr. DeVillio votes aye on bills 1448, 1449,
Okay,
1451,
thank you.
1452,
Okay,
1453, 1454, 1455, 1456, 1457, 1458, 1459, and 1460, and 1461, excuse me.
60 and 61? Okay,
Yes.
thank you. Okay. Thank you very much, Mr. Coopersmith. So with the exception of 1450, now let's move on to 1447. The chair would entertain the motion to move that to third reader.
So moved.
Moved by Mr. Lesher,
Second.
second by Mr. Callahan. Any further discussion on the motion to move 1447 to third reader tonight? Hearing none, Madam Secretary, on the motion to move to third reader, would you please call your roll?
Mr. Pack?
Aye.
Mr. Callahan?
Aye.
Ms. Price?
Aye.
Mr. Lesher?
Aye.
Thank you. 1447 is now before the council for third reader. Madam Secretary, would you please mind reading the bill?
Bill number 1447.
I ask that so much be considered a reading.
Any objection to Mr. Price's motion? Hearing none, 1447 is now before council for final vote. Any other comments on 1447 before you take vote? Okay, hearing none, Madam Secretary, please call your roll, 1447.
Mr. Pack?
Aye.
Mr. Callahan?
Aye.
Ms. Price?
Aye.
Mr. Lesher?
Aye.
Mr. DeVillio?
Mr. DeVillio votes aye.
Okay, 1447 passes. Thank you very much. Thanks for all those callers for weighing in on 1447 and then for all the bills. We certainly appreciate your time and being with us tonight. The last bill we're going to have public hearing on tonight is Bill 1446. Mr. Salinas is coming to the table to give us a brief comment after Mrs. Moran reads the bill and number and title.
Bill number 1446, a bill to amend Chapter 190 of the Talbot County Code, Zoning, Subdivision, and Land Development to improve and clarify the processes for licensure and oversight of short-term rentals in the county, and to amend the standards for safety for licensure.
Thank you very much, Madam Secretary. Mr. Salinas, we'll hear from you.
Thank you. I want to just walk the council through how we got to the Bill 1446 that's in front of you. This process started last August. The Short-Term Rental Review Board held 2 work sessions in August of last year to get an opportunity to get public comment on potential changes to the STR regulations. And in those 2 work sessions, they received over 90 written comments. I believe over 40 speakers spoke at those public meetings, and the board held 2 additional work sessions in September to discuss all the comments that they heard and to consider those comments, and that resulted in a letter to the County Council on November 14th, which offered up 24 specific recommended changes to the short-term rental regulations, which are actually in Chapter 190, our zoning, subdivision, and land development ordinance. Not all the recommendations that they gave the County Council required legislative changes, but several did. The County Council then held 2 joint work sessions with the board. One work session was in December, another work session was in January of this year. And in that consideration of those recommendations, as well as recommendations from the public that were not included in the board's letter to the council held straw poll votes. And that the text of Bill number 1446 is the outcome of those council straw votes. I won't go over the bill itself, the details of the bill. I believe you have a 1-page summary in Granicus that we provided you, which provided some bullet points on the bill itself. But what I do want to say is that the Planning Commission held a public hearing this past Thursday, and the Planning Commission recommended on a vote of 41 approval recommended to the County Council approval of Bill 1446. In their recommendation, the Commission asked the Council to consider 3 amendments to the bill. The first one would be that the owner, the STR property owner, or the license applicant be present at new application hearings in front of the board. There's a matrix that was included with your STR package. In that matrix, it's noted that this was discussed by the County Council at one of the joint work sessions, and that recommendation failed 2-3 by the Council in their straw poll vote. The second recommendation that the Planning Commission had was to require notifications to property owners within 1,000 feet, regardless of the zoning district that the STR property owner applicant resided in. The draft bill right now for residential and village zoning districts provides for a reduction of the current regulation of 1,000 feet down to 500 feet. That was also discussed by the County Council in their joint work session, and that resolution of reduction to 500 feet was approved by the Council 5-0 by straw poll vote. And then the third recommendation that the Planning Commission offered to the County Council was some amendments to the minimum safety standards that are included in this draft bill, or in this bill. Those recommendations actually came from staff, and those recommendations are intended to provide a little bit more specificity to those minimum safety standards, because we do have third-party inspectors, or we allow third-party International Code Council certified inspectors to do those inspections on the applicant's homes. We wanted to be sure that there was more specificity in that language related to minimum safety standards. And so those are the 3 recommendations that the Planning Commission wanted to, that they passed on to the County Council. I want to note that I have Mike Duell here. He's our Chief Building Official, and Brent Garner. I'm sorry, Mike Duell's our Chief Code Enforcement Officer, and Brent Garner, our Building Official. You're here in attendance in case you have any questions. I also wanted to let you know that, as you know, Mary Kay's on the line. I believe Scott Kane's on the line in case you have any questions. And Chip Council, who's the chairman of the Planning Commission, he wanted to me to relay to you that unfortunately, he cannot be here in person, but if you do need to speak to him, he is available by phone.
Thank you, Mr. Salinas. The only thing that troubled me with the report that we got was that the recommendation from the Planning Commission were items that council had already considered and already made decisions on, and they were either adding language back in that council had already removed or rejecting language the council had already approved. So I found that quite disturbing that the Planning Commission would do that. I believe that their task was just whether or not the matter before them is consistent with the comprehensive plan. We have an STR board, which is an arbitration board as well as an advisory board, and these matters were discussed with that board. And as you said, Mr. Salinas, when council had its work session with them, those straw votes were taken. So I'm just a bit troubled, and I'll pass this on to the chairman, why matters were put back in that council had already taken out, or verbiage that council had already approved, was then asked to be removed.
Well, I just want to make a comment on that. I mean, they were just straw votes, and they were not binding votes, so I'm always happy to hear additional recommendations. Maybe we missed something. They might be coming at it from a different perspective than us or the STR board, so whether we decide to include them or not, we can do it when we take our final vote, which won't be this evening. But I have no problem in hearing input from as many people as possible, especially, you know, the Planning Commission members, which go through quite a process to get onto the Planning Commission. So I do appreciate their feedback on it.
Okay. Well, that's fine, Mrs. Price. It's just that this doesn't fall within their scope of work, again, because it's outside their scope, in my opinion.
Mr. Peck?
Yes.
Is it in order to introduce the amendment so that the public hearing can address the merits of the content of those amendments?
I don't think these were actual amendments. These were just submitted to us as suggestions. Someone would have to actually make these amendments. These aren't amendments.
So we have in the attachment.
Yeah, they said they're proposed amendments.
last-
Someone have to basically offer them up as amendments.
Would it be in order to do that now?
Yeah, I mean, yes, if you wanted to offer these up, you can offer amendments up at any time. It'd probably be better to offer them up now as we go into the public hearing. But yes.
That way the public can.
Are they written out
comment on.
somewhere?
So if you go into the third attachment, the Planning Commission recommendations and related documents, it's a 22-page document, and the last 3 pages are in green, which are the amendment to Bill 1446, Amendment 1. The first one, Mr. Salinas described as the operating guidelines, referring to the minimum safety standards as developed by staff, sort of further refinements on those.
Now, this is section, this is under operation guidelines, item number, under 9A,
Under 9.
B, and C. Mr. Salinas, correct me, are these RFC language? Is this new language based on the RFC, or?
Mr. Chairman, I'd like to bring Mr. Garner up to answer that.
Why don't we do that?
Thank you.
So I can know where this language is coming from. Brent, good to see you.
Good evening.
Good evening. Brent, regarding the, I'm going back to the handout we received, under 9A, I'm sorry, 9B and C, the language that's added in, is that new language based on the RFC, or where are we getting that language? Why is it now being added in?
That language is through the IRC code book.
Okay.
Can you give me a page number on that, since it's 22 pages long?
This would be
Should have got a,
pages 20 and 21 of the attachment from the Planning Commission. Yep, there you go. It's 9, item B, item C, and then continuing on to the next page, there's some minor ones under D, E, and G.
smoke alarms, carbon monoxide, and rescue openings.
So this new language would be to, under item 9B, in the immediate vicinity of the bedrooms and on each additional floor of the dwelling, including basement and habitable attics, that there must be equipped with a interconnected smoke alarm in each bedroom. And then the added language would also be, so not only in the bedroom, but also in the vicinity of the bedrooms and on each floor. You're talking about the hallway would also have the smoke detector?
Yes, sir, that is correct.
And then also in the basement, and then also in the attic?
Habitable attic, yes, sir.
Right.
Mr. Pack, I believe, and Mr. Garner, correct me if I'm wrong, that's how we currently inspect those smoke alarms. And so this just provides a little bit, 9B provides a little bit more specificity for anybody who reads it, what they have to do.
Well, when we had the work session back several months ago, I thought we were trying to get out of putting more language and more restrictions on things and making people do more stuff. Now we're adding all this stuff back in. So that's going to add just a lot of cost to everybody, and I don't really see where that's, you know, I think we were coming up with our own and trying to stay out of the IRC, if I remember correctly.
Question. If this is the way you're already inspecting, is it just that you're adding, this is what's required, you're just adding language so it's more understandable to people right now, that it's not a change, it's not an increase in regulation?
Well, it's a change because if it's one thing, it's new, it's another thing if it's old and existing. So we have to be very sort of sensitive to older homes.
But smoke alarms are not a big deal to add.
Well,
Well, I guess interconnected, I mean, it's nice when they're interconnected, because if one goes off down in the basement, it's gonna ring upstairs, but if it is an older home, can you make an exception that yes, you have to have the smoke alarm in all these different places, but if you can't wire it down to the basement, that you at least have just a standalone smoke detector? Would that?
Yeah.
Because those are cheap, they're $10. So interconnected where,
well, in my opinion, we had it the right time, or we had it right the first time, and then now we've added things in to kind of clog it up a little bit.
So question for staff. This legislation will remove the requirement for full compliance with all aspects of the International Residential Building Code. Is that correct? And it substitutes these items, which are taken from these elements back in lieu of complete compliance with the IRC?
That is correct.
Right. Mm-hmm.
I don't think we should have any problems with smoke detectors and carbon monoxide. I mean, that's the first line of defense. I mean, if that to me is not changing huge window sizes and destroying the character of a house. I think we need the smoke detectors and the carbon monoxide, and they need to be connected. You know, whether you connect one down in the basement or not, it's not going to make or break, you know, anything. But I think, you know, sleeping areas and habitable areas, you got to have smoke detectors. These people are not familiar with these homes. They might be there for 2, 3, or 4 days. Smoke detectors and carbon monoxide, that's important, and I don't think we should take that standard down. The other stuff, I think we've made a lot of changes. I think when you brought us those safety standards as opposed to the IRC, I think a lot of those are fine, and it allows those more historic homes to not have to, you know, cut out a window and change that. But I think we should go with the smoke detectors and carbon monoxide. I think it's important.
So we go back to 9C. So 9C, as we originally wrote this, was to have the carbon monoxide monitors installed when a fuel-fired appliances are present. Now we have quite a deal of additional language. The first being that it has to be interconnected carbon monoxide. Instead of it being monitors, it says alarms. And then it used some of the same language that we find over in 9B. The alarm shall be installed outside each separate sleeping area in the immediate vicinity of the bedrooms where a fuel burning appliance is located within a bedroom or its attached bedroom. It says a carbon monoxide alarm shall be installed within the bedroom. Combination carbon monoxide alarm and smoke detectors shall be permitted to be used in lieu of carbon monoxide alarms, I guess, separately.
So you only have to have it in the bedroom if you've got a fuel-burning appliance in there.
That is correct.
Well, that makes sense then. I mean, if there's
Yes.
no,
So let me ask you something. Why can't we keep it the original when you have a carbon monoxide installed fuel-fired appliance, and that's it? I mean, why do we have to add all this extra to it? I'm just asking. I mean,
Because we're not giving direction to anybody doing an inspection. You're leaving it open-ended without specifying where and when they need to be installed and how. Just a broad statement to say carbon monoxide alarms installed where fuel-fired appliances are present. Where is that? Is that just one in one part of the house?
right, I get it. They might think there just needs to be one, and if there is one in the bedrooms, so this is just saying if there's one in the bedroom, you gotta put one there too. Right. If you don't spell it out, it doesn't necessarily get done. It's not
Exactly.
necessarily more restrictive, it's clarification.
Or it's up for interpretation by anybody.
Correct, right.
So you want to take some of the arbitrariness out of the inspection process?
Correct, and give them direction, and the reason you have one on each floor is because of the danger that might be imposed by a problem on one floor versus the other, or if you have an appliance that's in a bedroom, like a gas-fired fireplace, and your only alarm is on the first floor, where everybody's gonna die on the second floor before that alarm goes off on the first floor.
Okay. See, that actually makes sense.
do you need one at all if you don't have any gas in the house or natural gas? Do you need one at all?
You do not unless you have an attached garage, reason being somebody leaves a car running and it's attached to the house. And it's an odorless, deadly killer.
Okay. So let's jump over it because to kind of move this along. So you have on 9D, these look like they're just cleanups here, Miguel?
Correct.
You added the word width, a minimum width of 20 inches. On 9E, it looks like you changed exit to egress. Okay, that's fine. And then jumping down to 9G, you have some more cleanup, secondary emergency exit, and again, change exit to egress.
Well, when you change it to egress, does that mean you have certain standards of measurement instead of escape?
Correct, and that's the way the code was written, but it was, when you read what was originally put in there,
Right.
it was jumping back and forth. All we did was clean it up to make it the same.
Consistent language.
The language, that's all that was.
So just so I can kind of understand what you're saying, what's the difference between escape and egress?
Well, it's saying escape egress. What you're doing is you're, excuse me, with the changes of making it the 30 inches wide at all locations. So it's just telling you that that's an egress or your escape area, how to get out. And the reason being is that was just taken out of the code book as a clarification to make the language the same as we did in G also.
Okay.
And the last one in G, it looks like you added 2 additional words here. It looks like the roll-up ladders for use to exit A, and then you added escape opening window. I'm sorry, rescue opening window.
Rescue opening.
Okay. Okay, so those are just some minor,
Their terminology.
minor edits to those pieces. All right. And of course, I gave my comment on the inclusion and removal of language the council had already made decision on under 63.2.g, 63.2.g2, and 63.3.a4. So, Mr. Lesher, you're asking, we're moving that all these amendments be You're going to
Well,
introduce,
I'm
you're going
just-
to
I'm
introduce
just
the
asking
amendment?
to
You can
introduce
do it by
them
yourself.
now.
Okay.
I don't think we should vote on the
No.
amendments until after we hear from the
No,
public.
you're absolutely right, absolutely right. So, if there's no further questions, the chair would ask for a show of hands, for the
So,
introduction of the amendments.
Hang on 1 second. Are we including the amendments that the planning commission is offering?
Yeah, we talked about those initially. That
Right,
those-
but we are including them at the moment?
Yes,
for
yes, I
introduction.
just said we've already talked about those, that's why I read those separately. So, the chair will entertain a motion by show of hands for introduction of these amendments. Of course, Mr. DeVillio can't by counsel, Madam Secretary. Okay, so these amendments, for anyone coming up to speak on 1446, these amendments are now open for your comment. Gentlemen, thank you very much for being with us and adding your voice to it. Don't run away. We probably will be calling you back at some point as the comments start coming in. So we're now going to move into the public hearing of 1446. Again, there were these additional amendments that was just introduced by council, and if you want to speak to those, you can. And I will start with who we have in front of us, and on the first row, anyone on my left want to speak to 1446 STR? Yes, ma'am.
Me?
Yes, ma'am. You're there. And we just need your name, no addresses, please. And we'll give you 3 minutes on the clock. I'm sorry to go all around.
And I can just speak, I can't ask questions or anything.
You can't ask questions. I don't know if they're going to be answered, but you can ask whatever you choose to ask. Doesn't mean you're going to be answered. This
right.
is a public hearing. So we'll give you 3 minutes, and Mr. Callahan has the clock.
Okay, my name is Cindy Reichert. I had questions on what we just discussed, and that is, I'm trying to understand why the decision is made that for an STR, we care about all this safety, but for a B&B we don't, but for a long-term rental we don't. I don't understand what is the difference, that there are this many restrictions. And I think I kind of know because, you know, when these things were all came about, the Planning Commission, there was a gentleman by the name of Jack Fisher who wrote a letter on 12/14/18, open letter to the council, and he was totally against STRs and said, I don't even think these are strict enough, we should do more. And then when we heard the planning and zoning people talk this week, there was 4 of the 5 totally against STRs. So I'm kind of getting the feeling here that, you know, it's pretty lopsided, and there's not really anybody that's kind of trying to support STRs, who bring business to the county, who, you know, why are there so many differences and requirements for STRs versus for any other kinds of accommodations in the county? I could have a bed and breakfast right now. I don't have to do any of the, I don't have to get my water tested, I don't have to get the sewer inspected, I don't have to meet any of these safety requirements. I don't have to do a ton of all these things that cost the homeowner money, that takes time, that eats up all the staff in planning and zoning to run around and get all this stuff. I'm just trying to understand, how did we get to this situation where it's so strict for an STR?
Well, I'll just take a moment. A bed and breakfast requires that the homeowner be present on the property.
Yep.
And STR does not. When the last council was considering the rewrite of the STR code, that was one of the things we considered, the fact that you're having people come into a property where they may not be aware of any hazards that the property may present. With a homeowner on premises at all times on a B&B, of course, the homeowner is there to make them aware of any issues on the property. So that's one distinction between the two. In the long term, I mean, it's a distinction. You were asking, I'm giving you the rationale.
Got
You know,
you.
whether you agree with it or
Got
not,
you.
I'm trying to give you the
Got you.
rationale. With a long-term rental, someone's coming in as a nurse or as a visiting traveling doctor, they're going to be here for months at a time. So it's not where they're going to be, you're going to have people coming in and coming out of the dwelling on a week-to-week basis, as you may have with an STR. So there are some distinct differences between a B&B, a long-term rental, and an STR, and that's my 1 minute explanation.
Gotcha. Am I out of time, or am I still okay?
I don't know. Is she out of
Well,
time?
you got 30 seconds.
You got 30
Oh,
seconds.
you can give her an extra
The other thing that, you know, is not the same as a B&B, and I don't know why there was justification that this 3-day minimum, because people come to this county to enjoy the county on the weekend. Most people work, so they come on the weekend, but you know, STRs have to have 3-day minimum. I don't understand the justification of that either. It doesn't make sense to me. You want to bring people to the county. The These are people that want to stay in a home and stay together. They don't really want to, go, 3 couples get 3 rooms in a hotel, or 3 rooms in a bed and breakfast for that matter. So I'm just trying to understand why, I don't even understand how we got to 14 weeks on the other end either. That's kind of, doesn't make sense. A bed and breakfast is 30 days maximum stay. So it's kind of just, doesn't make sense to me.
Again, we had extensive comment about that as far as council regarding the 3-night minimum stay from the community. Again, a lot of this that you're bringing up was covered during those public hearings and those work sessions that Mr. Salinas referred to, which the previous council and this council held. So there was a lot of information about that in those public hearings.
And it didn't make it to there was a lot of people who came and said, why are we having 2 nights? We'd really rather have 2 nights, but that didn't make it into a change in this document.
Remember, this goes back to 2018 with the last council, and there was ad nauseum public hearings and lots of feedback. So I don't think these, if you want a change from 2018, then you ask for it. But to ask for clarification when we went through a very long, months-long process in 2018, I mean, for months and months and months going through all this, that's where it all came from.
Yeah,
So
but that was
a lot of it's just
2018.
carryover.
So how do we now make a change? We're now in 2020. How do we change any of these things that are pretty,
Again,
are prohibitive?
That's where we are here today. We had a work session with the public, with our STR board. There were
I attended all of them.
matrix made up that we went through. As Mr. Salinas said, one matrix was this matrix alone is just public comment.
I have
This
a
is not
copy
from
of
the
it.
STR board. This is all public comment. So this council and the previous council spent a lot of time on this. These aren't just numbers we pulled out of thin air. We listened to what people had to say. We listened to the STR board. We listened to county staff. We listened to the public, and documents were drafted. So you're coming here today asking, where did this come from? How did we get here? And Mr. Salinas just explained to you, this has been a long and arduous process.
I attended all of those, but what I'm saying is, I think that there were a lot of comments from pro-STR people, if you want to say, that didn't make it to that matrix. And one of them was, a lot of people commented on the 2-day minimum, changing the 3-day to a 2-day.
But there were an equal amount of people who wanted a week or 2 weeks, so we had to strike a balance and compromise. Not every side's going to get everything that they want.
I know.
So you have to
Seems a little
compromise.
one-sided, to be honest. That's all the comments I have.
Thank you.
Thank you. Anyone else on the second row on Bill 1446? No? Anyone on the third row on Bill 1446? I'm losing track. Fourth row? Yes, sir, give us your name. We'll give you 3 minutes on the clock. Thank you.
I'm with Talbot Vacation Advocates. May I have 5 minutes?
You may. Sure.
Mr. Callahan, may I have a 30-second warning when we get to?
Sure.
Thank you.
Yes.
I really appreciate it.
And you can take your mask off to speak. It's a lot easier for us to understand and.
Oh, you'll be able to hear me, don't worry. I appreciate that.
Easier for the stenographer, but.
Do you need to see my lips? Okay.
Whatever
so here we go.
you're comfortable with, sir.
Thank you, I
We can
appreciate
hear
it.
you.
My name is Keith Watts. I am with Talbot Vacation Advocates, and I would like to thank the council for this opportunity to speak tonight. Mr. Lesher, Ms. Price, President Pack, Mr. Callahan, and Mr. DeVillio. I see Mr. Garner's here, Mr. Hollis, and Mr. Cooper-Smith. All nice to see you. Chief Duell, a pleasure. A couple of comments. It occurred to me that during the earlier testimony about egress that Mr. Garner was providing, P.T. Barnum once said, "This way to the egress." He posted signs all through his museum. Nobody knew what egress meant. It was the exit. It was a way to move people through, except that no one knew what it meant. So I'm not so sure that it really provides the clarification that you think it does. Maybe it provides clarification to the inspector. I'm not really so sure about that. I can tell you about a recent short-term runaway review board hearing where the application came before the board, and what was noted was that this was 3 bedrooms, or was it 4 bedrooms? And when the inspector came, he didn't pay attention to the fact that there was a room that was being used as an office, but it's still the dimensions and space of a bedroom. And our fine President, Mr. Kane, told him, well, you can either come back next year or we'll move forward with this as a 3-bedroom property. Even though the dimensions were there and the inspector could see it, and an inspection had already been scheduled to cure the defect. Yet Mr. Kane said, nope, I'm so sorry, we can't do that for you. It's either this or nothing at all. Come back next year. Come back next year and we'll have the inspection then. I don't think that any of the people who are sitting up on that dais today, I don't believe that that is your intention. I don't believe that some of the things that the public has asked for, and listen, I am all about you folks having a long, arduous process. There's no question about that. There's no need to go back and forth about how many work sessions there were. What the previous speaker talked about, things not making it into the matrix, that's a fact. They didn't get in there. And there may have been comment about it. There simply is no way to justify. I respect the comment that, well, we needed to reach some sort of a compromise between 2 weeks and 1 day, so we made it 3 days. How is that practically applied as one? That's what one has to ask yourself. How does that practically apply in the real world? Not the netherworld, all right, but the real world. How does it affect Talbot County every day? How does it affect the people who are coming to this county and spending money? They don't have 3 days. They have a 2-day weekend. If you're thinking about giving people 3 weeks, or 3 days rather, that's fine. Not good for the county. It's not how reality works. It doesn't help the businesses. It doesn't help the landscapers, the pool people. It doesn't help anybody. This is something that was, look, there are some people apparently who are in it to win it. I don't know what their beef is. I don't know why they don't like short-term rentals. Maybe they live next to one. Maybe they don't. But we don't take a broad brush and, sorry about that. If you do that one more time, you're going to get out of here. We don't take a broad brush and taint it, right? That everyone is bad. Why do we proceed from the point of view that all STR, we assume the worst about them? Like the barbarians at the gates, blackbearders sailing up the Miles River, burning and pillaging. You can have Chief Duell come up and tell you how many fires have we had where people didn't know how to get out. You're talking about long-term renters. They're there for months at a time. I grant you that. That's absolutely true. What about the first 3 or 4 days that they're there? What if there's a fire then? It's the same thing. They're not familiar, so the familiarity argument, I understand the safety issues, but to Honorable Callahan's point, a former fireman, if I'm not mistaken, or maybe still a fireman who would be an expert, I might add, who might know a little something about entering and egress.
30
Okay.
seconds, Mr. Watt.
Thank you. Look, the devil is in the details. The public never saw what was just sent to the council. To President Pack's point, it's very disturbing to the public when things are added at the last minute and we don't have a chance to see it. We don't even see this language. Oh, we claim it's a clarification, but we don't see it. The devil is in the details. 2-night minimums, fix the occupancy. That's absurd, okay? Only 2 people per bedroom can be on the property at all times, so when the mail is delivered, if you've already got 4 renters there, sorry, that's a violation. Chief Duell, write the $500 ticket. Oh, by the way, one last thing. Flexibility. I agree with Councilperson Lesher. He says, well, why not have flexibility? Don't we want the flexibility to not suspend the license for 12 months, right? I think that's a fabulous idea. Fabulous. Why is it that we insert the flexibility there, but we don't insert the word may, right? The same word that may enforce the flexibility issue for the 12 months. Why don't we insert the may, okay, with respect to the $500 fine? I would suggest to you what Chief Gamble sat here and said about the 134-page bill. Read the bill. Read the 14-page bill. Go through it line by line, and I beg you, have a work session where the public can comment to you directly, line by line. I guarantee you, you will find things in that bill that will surprise you and that will make no sense to you, and other things will make perfect sense to you. And we're very surprised. Who can argue against safety, right? But when, as Mr. Callahan pointed out, you start adding all sorts of things in there, and more and more and more. One last point. A complete, the word complete was added. A complete application. And Mr. Kane made a big point out of that. Well, this application is not complete, so you know what that means? Push the eject button. Oh! Goodbye, Charlie. Come back next year.
We're about done, Mr. Watts. Okay.
Thank you very much. I yield my time. It's a pleasure to meet you all in person.
Yep, thank you.
Anyone else on the left for 1446? Mrs. Morris, do we have any callers on the line for 1446?
Yes, we have two people that have identified that they wish to speak.
Okay.
The first is Woody and Gussie Dunstan. I'll
Okay.
find them in the system.
So we'll give them 3 minutes on the clock. Are they ready?
They would each like to speak, so 3
Okay, so we'll
minutes
give
each.
them 3 minutes each to speak. So who's first?
Okay, Mr. and Mrs. Gunston, can you hear me?
So if we could ask for 6 minutes, I don't know what we'll divide it exactly.
Well, I'll give one of you 3 and then the other one 3. So who's going first?
Okay. We have prepared comments, but we are owners, and we would like to give you a perspective as an owner. Hopefully, at the end of our comments, you'll understand why it's particularly onerous for owners to, for example, be present at every meeting. We are State Department diplomats serving our country in Turkey. Prior to that, in Serbia last year. We cannot be at meetings. But in any case, honorable county council members, first and foremost, as 15-year resident of Talbot County, thank you for the decisions that you have made and still making to ensure that our county's public and economic welfare in the COVID-19 crisis is ensured and balanced. It seems that measures across the work well in our county. We hope that Talbot County City support is working. We also respectfully ask the Talbot County Council not pass Bill number 1446, which would surely and permanently limit tourist access to our county and be to the detriment of vast number of businesses dependent on tourism. As well, it will devastate homeowners like us who need the income to survive ongoing economic threats. We moved to Talbot County in 2006 and lived on Church Neck Road in St. Michael. That home is our only home and property. We are a foreign service family and therefore posted overseas. Last year, we returned from a 3-year tour of duty to Belgrade, Serbia. Last August, deploying on PCS orders to Turkey for 2 to 3 years. For medical reasons, we temporarily got out of Turkey in May, and serendipitously were able to enjoy our home in St. Michael's for a couple of weeks in July. We have 3 children, one a college graduate last year, one in college, and one is rising 9th grader. While we have stayed via a 529 plan for college all of their lives, the ever-accelerating tuition cost has hit us very hard for 6 years to date. We are halfway. Boston University, where our daughter is a junior, raised the cost of tuition, room and board by 3.6% next semester to $72,000 for the next year. Last year, to meet that tuition, we made the very difficult choice to rent our home, our one and only home, during the tourist season. This allows us to return to St. Michael's during official R&Rs from our assignment to Turkey, for example, at Thanksgiving and Christmas. It is the only way we can afford the incredibly high cost of college tuition. As Miguel Salinas can attest to, thank you, Miguel, for your help last year, when we first made an application in February 2019 to participate in the SDR program, it took half a year to finally get our permit. As you know, Talbot County radically and capably changed the rules for short-term rentals last year, apparently an overreaction to isolated complaints of seasonal rentals gone bad. Our agent, East for vacation rentals, and we began the process many months prior with the application fees, registered letters, and names as instructed. By the time our permit was approved, it was July. Too late to take advantage of summer rentals. Yeah. We had 2 rentals, barely recouping the cost of participation. This year has been successful thus far, and we've lived at the semester, one semester of college tuition. But we are now horrified that Bill 1446 is on the table.
I thought he said 6. I thought he said 6. He said 2 and 2. It was a group. It was a group, wasn't it? Yeah.
Consider our very typical case of trying to generate information from a personal property. My wife, Betsy.
Thank you.
Right.
We have 3 points. First, we sincerely believe that the repeated attacks on SDRs and the result of some misperceptions about SDR property owners and their renters, which is unfounded and unfair. We personally have to defend against when applying for a permit. It is tyranny of the few. For example, a prominent resident of Talbot County, whose name begins with D, and is from a wealthy chemical company of fortune, wrote a letter protesting our application. This person got asked about her home, which is never seen, size, rooms, etc., which are absolutely inaccurate. She doesn't live within 10 miles of us, and we have never met her. If we believe, for example, is typical of those protesting SDRs. They prophecy against prophecy for the wild, fire-experienced tourists descending on Talbot County, disrupting our quiet corner of necessity, and leaving.
You have 30 seconds left.
The reality is that most of us who moved to Talbot County do so because we fell in love with this magical place at first. Then, once smitten, chose to invest in a home and move here. 90% of our neighbors within a mile of our house were first here. Many, including us, use SDRs as a reasonably priced way of experiencing life here before committing.
We understand that, and with that endeavor, there are occasionally bad apples. It happens that.
Could you wrap it up, please, or your time is up, please?
It's not a group.
All right, it's clear that homeowners are not getting it. Okay, we will give up our time, but please listen for a second, because it's clear that homeowners are not able to participate enough. You have all of these meetings that you referred to earlier, but keep in mind, by definition, we are not able to be present. We serve our country overseas as diplomats. And I ask for another minute to remind you that, it's fine, any homeowner or agent who has a bad apple renting, absolutely, their permit should be removed. But at the end of the day, it's the homeowner that takes the risk. It's the homeowner who pays the fees and taxes, and all of these new rules cost the homeowner, as well as Talbot County businesses, by the way.
Mr. Gunston, I'm going to have to stop you right there. Thank you very much for your comments. You and Mrs. Gunston, thank you for your service to this country. We do advertise all of our public hearings well in advance to make sure that even persons who are not in the county at the time of the public hearing can either send us written comment. We all oftentimes even extend that public comment period to allow for additional written comment, which is given just the same amount of weight as if someone was coming before us. So the council does try to give proper and advance notice of any and all of our public hearings to make sure persons can give either written comment or be with us in person. Mrs. Morris, is there anyone else on the call?
Yes, the next caller is a Miss Annette Miller.
Okay.
Miss Miller, can you hear us?
Yes, thank you for the opportunity to speak, and I do thank you that you said you're not going to vote on this tonight.
Correct.
Because this is really important. My husband and I are SDR owners, and we are members of the Talbot Vacation Advocacy Group, and we support all of the comments that have gone on behalf of our group. We are longtime vacationers in Talbot County, and we're fairly new owners. We bought our home after floating in a pool at an years on restoring. It had been on the market for 10 years, and it had fallen into disrepair, and we have, just through the grace of God and the help of others, been able to turn it into a lovely home. We bought this home to retire to, we hope in the near future, and in the meantime, like the couple that just spoke, we are not wealthy people. We are very hardworking former farmers, and we just have come to love Talbot County, and that is where we want to live out our retirement years, God willing. However, through all of the things that we've gone through in getting our license and going through hearings, it's been very difficult, and it's also been, in some levels, humiliating. Some of the comments that were made about how much we spend on our home, how cheaply we got it, and now we can afford to make all of these changes that were being put before us, were just a little bit humiliating and discouraging to us. And to see these changes continuing to take place and language being added in that we don't even have time to see, let alone comment on, is also very difficult for all of us to stay on top of. We have a lot of concerns. There's a lot of things going on with the changes with going back to possibly a 1,000-foot notification. We sent no less than 54 letters twice for our application. It was very costly, and it upset some neighbors that don't even live close to us. People that we don't impact at all. We have a very private location. We're on 3 acres on the water. That's been, the whole process is very onerous, as someone else had mentioned. And then having to put a sign in the yard to announce that we were applying for this and having a hearing, and putting it on a home that is, it kind of puts out a sign that we are empty at times. And I feel like, especially in these day and ages, that's a huge security issue. One of the other issues that causes me to lose sleep is this 12-person occupancy, the 2-person per bedroom. We have a 4-bedroom home. That means we can rent to 8 people. Sometimes that's just a family, grandparents, children, and parents. But we have 2 guys come and mow our yard on a weekly basis, and I think our neighbors would object if we didn't do that. So when we are full capacity and they show up, we're out of compliance, and a neighbor could turn us in and cause us a really large fine in that case. Or, we have a pool that has to be maintained. But any other maintenance we have to have done always puts us at jeopardy. And I'm also asking tonight.
We could wrap it up, Ms. Miller. If we could wrap it up, I'd appreciate it.
We're all about having things regulated. You have to regulate things, but we're asking for fair and reasonable regulation based on facts and knowledge, not emotion, not fear of things that are not known and that are not happening. And I thank you so much for the opportunity to speak and to listen to us, and I just ask that this bill will not be passed as is, and that there will be more opportunity for public comment. Thank you very much.
Thank you very much.
Thank you, Ms. Miller.
Anyone else want to call Mrs. Morris?
I will open up the line to the phone-in callers.
why don't we do that?
And while I'm doing that, I did want to let you know that Scott Kane has joined the meeting, and he is available if you have any questions for him.
Not at this time for Mr. King.
I have some comments I'd like to make, please.
Who is the caller?
Steve Gibson.
I'm sorry, once again, please?
It's Steve Shimko, I believe.
Mr. Shimko? Okay, Mr. Shimko, we're here from you. Go ahead. You got 3 minutes on the clock.
Okay. I just want to say that I support Bill 1446 as amended by the Planning Commission. I think that the changes that the Planning Commission recommended are the right thing to do. I think we'll address one thing that Ms. Riker said. He seems to be questioning the differences in the regulations between short-term rentals and B&B in particular. And my response to her is that she might be willing to entertain some of her suggestions if she would be willing to accept the same 500-foot separation between STR that pertains to B&B. The 500-foot separation was one of the things that we thought was a reasonable restriction on STR to prevent them from overcrowding high-density neighborhoods like 70A and Rio Vista, and that was not making it to the step 190 update. But if you want to entertain some changes along that line, I think some of them might be willing to do that. And then some of the other comments had to do with people not seeming to be aware of the changes and the process that we went through. The Bill 1446, as Mr. Salinas mentioned, is a result of a process that's been going on for approximately a year now. There were approximately 85 to 100 comments that were received by the planning and zoning made it into the matrix. Some of the suggestions made into Bill 1446, and some of them did not. But for somebody to say they did not have an opportunity or did not know what was going on with this process, it is rather hard to look at. Thank you very much.
Thank you, Mr. Shimko. Is there another caller, Mrs. Moss?
Is there another caller on the line that wishes to comment on Bill 1446? Okay, please identify yourself by name.
Laura Carney.
Laura Carney.
Ms. Carney, go ahead, you've got 3
Ms.
minutes.
Hi, I'm just the magazine, and if I could give people a request for that Miller, and keep watching that under children and women.
Ms. Miller, can,
Carney.
I can't understand what she's saying, and I don't think the stenographer can either. She's going to have to speak slowly and loudly.
I think there's an echo in that room. Can you hear me now? It's not us. Can you hear me?
Yes,
Yes.
we can hear you. If you could just speak slowly, we should be able to capture your comments.
Okay. Do you need my name again?
No, we're good. Laura Carney, correct?
Yes.
Thank you.
So my husband, Greg, and I are SDR owners on Travelers Rest. And I would like to just reiterate what the Nat Miller and Steve Watson said in regards to the changes that have been made or put in by the planning commission. And specifically in regards to the requirement for the notification of 1,000 feet, and there was a strong vote taken. And it just seems as though some of these things are split, and now we're talking again about it being back to the 500 feet. And I feel at times that we are going in circles. The same things keep getting discussed, and the council will give us a vote. And we think we moved on, and then we come back again. And it's just a little frustrating. The comments about the safety changes, which were all about safety, but we just installed all of the new smoke detectors that were interconnected. We installed the carbon monoxide detectors at each floor. And now it's coming in that these carbon monoxide needs to be interconnected. Again, it's just overkill, and it's just changing. I don't remember, I think Corey, Pat, objecting to it in the beginning. I think that is what to have to keep going over this stuff is I just don't think it's necessary. And I, especially in the economic state that we're in, and also the publicity. I had a driver that wrote somebody there today. That time was in, there's probably too many people with there. It's very difficult to say that.
Yeah, she's very bad, Ms. Carney, your time's just about up.
Okay, I think I'm about done. That's all I have to say. Thanks for your time.
Thank you, Mrs. Carney. Anyone else, Mrs. Morris?
Is there anybody else that wishes to make comment on Bill number 1446?
I would like to please.
Okay, could you please identify yourself by name?
Susan DuPont.
Thank you, Mrs. DuPont. Go ahead.
I would just like to echo my support for Bill 1446, combined with the amendments that the Planning Commission offered and Mr. Lesher brought forward. Listening to the planning commission meeting reminded me of Mr. Fish's letter, and it reminded me of notes that were in the matrix that they worked up over the at least 2 years, I think, that they worked on how to address what they saw as diminished quality of neighborhoods by 2018. And the philosophy behind it, I think, is what was moving them forward to considering neighborhoods, to be considering transparency, safety, and the notifications that, at 1,000 feet are balanced by the fact that as 1446 takes shape, which I hope it does after all this time and work, will only be one notification required. And to clarify that the occupancy leases that I looked at remind renters that the work people that come on the property are allowed to come on and please don't send them away. And that to me implies that they don't count in that particular concern. Thank you all for the hard, thoughtful work that continues to go on with this very complicated issue.
Thank you, Mrs. DuPont. Next call.
Is there anybody else on the line that wishes to comment on Bill 1446?
Yes, I would.
Okay, please identify yourself by name.
Yes, my name is Monica Adi.
Thank you, Ms. Adi. Go ahead.
Okay, well, I also support 1446, and I support the amendments proposed by the Planning Commission. And first of all, I would like to thank the planning and zoning staff, the short-term rental review board, the Planning Commission, and the council, because this bill is a culmination of a lot of work by all those organizations. And as Mr. Salinas explained, reflects 5 days of work sessions and comments from, I think, about over 90 people wrote in and 40 people testified. So there's been a lot of thought and a lot of consideration of public input. Most of the provisions in this bill are really designed to streamline the STR application and enforcement process. One of the current callers mentioned a problem sending out 2 notices. Well, if this bill is enacted, there's only going to be the need for 1 notice. And some of the other provisions were designed to try to streamline code and safety procedures. The Planning Commission did identify a few areas. The notice requirements, the 500-foot notice requirement in the bill applies only in the dense zone. And I think those are the zones where more people are likely to be affected by short-term rentals. So I don't think it makes sense to cut that notice provision from 500 feet or from 1,000 feet to 500 feet. And I do think it's already been demonstrated in the hearings of the STR board that having the the owner participate in the hearing can really be helpful. It can help head off problems before they happen. There was one application from last year where a neighbor was concerned about hunting at the STR property. So the owner said, oh yeah, okay, I'm just going to tell my renters they can't hunt. So there's your problem solved right away. And I don't know if that would happen if the owner had actually not been there. And, certainly in circumstances like we have now with coronavirus, if an owner can't physically be present because of extraordinary circumstances, the board can make arrangements for him to call in. So, as I said, I do support the bill and with the changes recommended by the Planning Commission, and I thank you very much for the opportunity to comment.
Thank you, Mrs. Adi. Any other callers?
Anybody else that would like to speak on bill number 1446?
Yes, I would.
Okay, please identify yourself by name.
What was it?
My name is
Dale Miller.
Dale Miller.
SPR. Yes.
Okay, go ahead. Thank you, Mr. Miller.
I'm an STR owner, and I think, in trying to listen to both sides, as I always do, I think most of the frustration coming from STR owners is, while there was many work sessions and time for public input,
don't feel as though we got consideration in the process. And I know it's not always fair, but that's where it's coming from. And when the bill continues to evolve, more stuff gets added in, that becomes a burden. It complicates the process. We have an existing building code last time I checked, and that gets updated regularly. But now you're adding more to that, which complicates it. Then you get into gray areas where the verbiage isn't quite right for understanding exactly what it means. If the building code is fine for the state, why does SPRs have to have additional? That's my question. I also do not like provisions in the bill with regarding to a 3-night minimum stay when you have most people coming that work and they want to stay for 2 nights. It limits use of that with a 3-night minimum. The other confusing thing is with regards to occupancy. And I understand the overnight minimum, but if you have other personnel showing up through the day, I don't agree the way it's currently written. Currently written does not specify if it's service personnel or other personnel. We would be in violation of the way it's currently written. So that's pretty much what I have to say, and I'll yield my time.
Thank you, Mr. Miller.
Is there anybody else on the line that wishes to speak?
This is Jody Hardesty.
Okay.
Go ahead, Ms. Hardesty.
Yes, thank you. One of the things I want to reiterate that hasn't really been brought up this evening is the process by which homeowners and resident agents are applying for these licenses. It's a 16-page application. And then, in addition to those 16 pages, a copy of the deed is required, plat is required, floor plans are required, the inspection is required, multiple letters are sent out, and then multiple copies of all of these things are provided to the planning zone. It ends up becoming a burden business, paperwork, nightmare. In addition to all of the paperwork that are submitted, the renewal process requires all the same documents. So what has already been turned in and being held in a file required all over again. So right now, Bill 1446 does not address the redundancies that are within the application process itself. And so I would like to see that eliminated because it's unnecessary at this point. In addition to re-examining the 3-night minimum and a 2-person per bedroom occupancy limit, particularly during the day. If somebody is visiting the area and has family in the area, they are in violation if one person sets foot on the property just to take a look for the day or swim in the pool. So there are little details within this bill that currently don't make a lot of sense and are ripe for unnecessary violations, I think, for homeowners and renters alike. So I would like for those things to be considered before drafting or voting on this bill or possibly drafting the bill to address these redundancies and the burdens of process of the application. Thank you.
Thank you very much.
Is there anybody else that wishes to speak on Bill 1446? Going once. Anybody else that wishes to speak on Bill 1446? I think that's it, Mr. Pack.
That's it? Okay. That's it. Is there another caller there? Okay.
May I ask a question of clarification of staff?
Sure.
If a maintenance worker, someone cutting the grass, cleaning the pool, that does not count against them, does it? Here comes Miguel. I would think that would be absurd.
Yeah, maintenance workers on the property, Ms. Price, the male person, landscapers, gardeners, those aren't included in, we would, if there was somebody doing some work on the property and we received a call, we wouldn't, and there was a complaint that there was too many people on the property, I don't think that would be part of our enforcement. They're temporary. And they're not associated necessarily with the STR rental, they're associated with other things that are happening on the property.
I mean, I wouldn't think it would be necessary to add an amendment clarifying that, but sometimes, like we just talked about, you have to spell it out. So maybe we need to add verbiage that anybody that's doing maintenance work or work on the house, construction, Mr. Callahan shows up, you're not going to throw him out or be in violation. So it seems silly that we would have to do that, but maybe it's some language we can throw in there just to clarify. So because we had 3 or 4 callers who said that they would be in violation from the mailman coming, and obviously that's not the case.
Anything further? Okay, thank you very much, Mr. Salinas. I do want to remind everyone we're not taking any vote on 1446 tonight. What we'll do, though, is we'll leave the public hearing open on 1446 through this coming Friday, which will be the 17th, Mrs. Moran?
Yes.
So public hearing will remain open on 1446 through this coming Friday, which is July the 17th. So if you wanted to go ahead and write us and share with us your comments, you certainly can. We'll entertain those. This council and the prior council did a lot of work on this STR legislation 2 years ago. There was basically no STR regulations in place. It was through the council taking time to sit down with people in the community and with staff, and also with the different organizations that represent STR owners, that we were able to come up with what you have today. This legislation is still in its infancy. Somebody had made comment, the devil is in the details. Well, quite honestly, we don't know those details as yet because we're still in the infancy of this program. Nothing will be decided tonight. I'm sure that we'll have much discussion going forward, this council will, before we take final vote on 1446 and the accompanying amendments from the Planning Commission. Again, I did give voice to that. I believe that those comments were not appropriate coming back to us because council had already made a decision on those, but we'll address that at a particular time. This public hearing is not closed. We're going to suspend until this coming Friday, the 17th. Close of business. For anyone who has any comments, please send those in to us, and we'll entertain those at a later date. All right, thank you.
Question,
Yes,
Mr.
question.
President. So are we going to put the new the new regulations that have been ingested in this bill so the public can see it?
The amendments?
Yeah, the amendments?
That'll be posted now, won't it?
The amendments that were introduced tonight?
Yes.
Are they on the website? Yeah, we'll post them on the website.
So, and so with some of these comments with people, like they were saying, and had some concerns about us putting stuff in there without, looking at it, and it was the first time we seen it, is there an opportunity in the next several weeks that we could actually, put more into it? Meaning some of this stuff that the public wants us, like the 2-day, or can we put that in?
When you say put it in, are you referring to as to amend?
Mm-hmm.
You can offer an amendment at any time, Mr. Callahan. You can offer an amendment in writing prior to it. You can offer an amendment as we did tonight during the public hearing process. or
So
prior
do
to
you-
the vote being taken, you can offer
Right.
it. You can
Do-
offer it at any time.
Do you see what was done tonight as an amendment? Because it is an amendment to what's there.
Those are amendments to the bill, yes, they was introduced as amendments to the bill,
Okay,
yes.
okay. So we can offer our own amendments.
You most certainly can,
Okay.
yeah.
Other thing, the
Okay.
only thing I would leave people with is that this, while it might not seem like it, if we don't pass this, you're still under the stricter regulations, the 2 mailings, for example. So while you, again, not everybody might be happy with this particular legislation and they're urging us not to pass it, understand if we don't pass this, then you're under the stricter regulations and we're still back to only taking applications 2 times a year. So maybe this is going to be a multi-step process that we pass this. That doesn't mean that we can't come back and revisit some of the concerns that we're hearing about. So maybe, you know, we've, since we started this a couple of years ago, and it was, as Mr. Pack said, it was new. We didn't have any short-term rental regulations. We got a lot of it right. We got a lot of it that we need to make some changes to, which is what we're doing, the process we're going through now. And we may need to continue to smooth out some of the bumps in the road. So it's not going to be perfect. But if we don't pass this one, then you're still under the old one, which is, I guess, for the people who are advocating for relaxation on short-term rentals, you're under the stricter rules. So just keep that in mind, that we might need to do this and then consider another round of a couple more amendments.
Okay, so we are not, this public hearing is not closed. You can give comment up to this Friday, the 17th. Thank you very much. Mr. Hollis, I believe that's all that I have. I'm going to turn the rest of the meeting over to you for county manager's report.
Thank you, Mr. President. Mr. Edwards is coming up, and he's requesting your approval to purchase a stone chip spreader from Chesapeake Supply and equipment out of Felton, Delaware, in the amount of $350,000. This funding is included in your capital outlay budget. For this fiscal year, I believe there's a several-month lead time, which is one of Mr. Edwards' concerns. So Warren, if you want to speak to the council.
So the chipper we have now is a 2008, and it's been giving us problems for about 4 years, really bad electrical issues, and we've repaired it to beyond repair. The newer machine will also allow us to shut down a road and do it all one width, so we don't have that overlapping of the crown of the road, which we've been trying to, that's why we mill so much. And there's only one vendor that can do this, and that's Etnar, which we're requesting.
Okay.
So council budgeted $1.639 million for this current fiscal year now in capital outlay.
So that total 1.6 million is unallocated. We didn't make the decisions within, I remember reviewing this item back at budget hearing time.
So the 1.6 is built on approved items that were not allowed to be moving forward until council gave approval, so yes.
So we have about 2 million in contingency, right? Because we're 2 different things. We've got about 2 million in contingency, I see Ms. Lane back there, for operating type expenses, and then we have the 1.6 in capital outlay. And when we did the budget, and we're only 14 days into the fiscal year now, we really don't have any answers yet. So in my opinion, this is a little too early to be putting things into the fiscal year budget. The state is making, obviously, some cuts. I will share, and it's not necessarily specific to you, but one thing that's on the table is withholding our income tax revenues, like the state not making those distributions. So while I will, see the net need for a lot of these things that need to happen, until I get some clarification, I mean, not only are our revenues going to go down in income tax, I literally was on a call last week that this budget secretary Brinkley was on, and he said everything is on the table. That really made me extremely nervous, and it's new information. I never dreamed that would happen. I have shared that with the finance director. We don't know what that number will be. So I'm probably not going to approve this early on in the fiscal year, some of these expenses, and it's by no means a reflection on the department head, or the need. I just don't know if we're going to have the funds. You know, we specifically put $2 plus $1.6 million away to decide as we went through the fiscal year, and as I said, it's only July 14th, so it's a little early for me.
So can I respond to that?
Of course.
So keep in mind, you cannot rent this piece of equipment anywhere. They do not rent them out. And 85 to 90% of our roads are all tar and chip. So when things do get tight and we don't have an asphalt budget and we can only tar and chip and this thing tears up, we could be a year waiting on it when you say go ahead. It's now 5 months to a year getting it as it is.
Do we have one now, and this is a replacement?
We do. Mm-hmm.
So what's the resale price, and you say here in your memo that you think you can sell the current machine outright? What's the net on that?
It just depends. I would say somewhere between 30 and 60. And the reason I say that is because this machine now opens up to 16 feet. So if everything broke down on it, they could still use it at 11. So there are contractors that would be interested in a machine that everything works on but wouldn't open up. So there's a resale market out there.
Is there any market, Warren, for used, that you could pick one up for 120?
No.
No.
Not 22 foot.
No.
Mm-mm.
So is it that you've identified a specific one that's available right now, or if I said, you know what, I really want another, you know, I want to get to the end of August and see what DBM does?
They would have to build the machine. There's none available.
So you're making the request now, but I mean, it's possible to
Well,
come back.
I've made it for the last 2 years.
I understand. No, I understand, but I mean, when I heard what I heard last week, and that could be incredibly detrimental to us, you know, is it something that you can hang on to for another 4 to 8 weeks? And, you know, because I think we are going to get some clarification. They've made some of their budget cuts from the BPW is allowed to do 20%, and they haven't finished doing that yet. So I'd just like to get a little bit more handle whether they're really going to go down.
Well, we're going to do whatever council decides we have to do. I mean, we're still making it work now, but,
Well, Chair, entertain a motion. This is for a stone chip spreader. The price on it is $350,000. It's to replace a smaller spreader. This is a 22-foot as opposed to a 16-foot spreader.
and this one's electric over hydraulic, so it doesn't have all the problems that the other one has.
Mr. Edwards thinks he can resell the current spreader net between $30,000, $60,000.
Yes.
Mr. Pack, our ability to have the in-house ability to maintain our tar and chip roads, I think is critical to maintain. We've heard testimony, not just today, but in the budget hearing process about the necessity of this piece of equipment. This was really outlined as a priority. We don't know how much time we've got on the existing piece of equipment, as Mr. Edwards has testified. I think he's made the case for the urgency of this piece of equipment. We do have this funding set aside in the capital outlay budget for this year. I think we've heard a compelling case for moving forward with it, and we know as we've heard tonight, there's a long lead time on this. This is
It is 20% of the entire part of that 1.6. I mean, it's not a small item. It is going to eat up 20% of it.
We got enough money sitting at the spoil site to buy 4 of them, but we're not selling anything. The material that we've recycled, but we're not selling anything, so.
Give their motion.
We're working every day trying to make it happen.
Just one more thing. So with all your wants and needs that you've come to us for, you know, through the budget hearing, okay, is this the most important thing?
Yes.
It is.
For the roads, yes.
Okay.
Well, if we run out of money for asphalt, we can't pave. But we have so much tar and chip we have to maintain and repair.
I understand that, and I think you have told us what you need. I think you've been waiting. We are, you know, in a budget crunch, you know, but just like Mr. Lesher said, I think we need it the problem I have with it, if something breaks down now, we're in a punch right now. If something breaks in the next 6 months. So, you know, I don't think we have a whole lot of choice.
Council, just so you know, this was Mr. Edwards' #1 priority in the budget request. It is the only capital item that was approved to stay in the capital item listing out of the 11 items that he requested.
With that information, I'll move for approval.
I second it.
Madam Secretary, please call your roll.
Mr. Pack?
Aye.
Mr. Callahan?
Aye.
Ms. Price?
Aye, this time.
Mr. Lesher?
Aye.
All right, thank you. Next item, Mr. Hollis.
Council, the next item is just for your information, actually. It's about the work you're going to be doing at the repurposing entrance.
Yes.
Highly visible. Just brief the council, please.
Yeah, I will. So it's, the road, the shoulder has been breaking up for probably 10 or 12 years, and it's breaking up really bad. We have such a good relationship with State Highway, and because the entrance is existing for over 30 years, they're not going to require us to get a permit to upgrade it as long as we do it in-house and not use a contractor. So we have the money in our budget to do it. I'll just use money out of the asphalt budget, but we have to mill out the entrance with our smaller machine and then excavate out 9 inches and then pave it 3 inches, 3 inches, and 3 inches. So it'd be up to State Highway specs. It could easily be $200,000 for curb and gutter and XL, decel lane and all that. They're not requiring any of that stuff. And that has nothing to do with whether the repurposing center passes or doesn't pass. It's because we use it for our own use. And it's been going bad a long time.
So we're going to go ahead and do, is it $14,000 for this repaving of the shoulder?
Yes.
For the shoulder?
Well, it'll be the entrance. It's the shoulder and the entrance in, like 12 feet in or something.
12 feet in.
Just,
Yeah.
so you're not going to go all the way back to where everything is?
No, not at all. And it just, I wanted you all to know what was going on, because somebody will call and complain and say, why are the roads department doing this? And, you know,
Is 12 feet the standard that the SHA goes into a?
from the edge of the shoulder, so it would be 18.
18.
So you have the shoulder, then you would go in 12. It depends really on the district. They can ask you to go further, or they can say you're okay going back, 6 feet off the shoulder with asphalt.
Yeah, when we were doing, when they did 50, they would go into like Dutchman's, maybe 12 to 15 feet.
Well, it's a whole different standard for Route 50, like Route 50, 301,
Yeah, that's what I was asking,
213.
if there was a set.
Yeah, no, there's a different standard for a higher volume, heavier truck route. That probably should be a higher volume route, but I'm not going to argue that. Well, we're going to do a work. It will last.
16 feet in?
Probably 20, whatever it takes to make it right and drain.
Okay.
And that
Chair,
doesn't need
No
council
motion,
approval.
just to make sure you got the money you're going to go.
Yeah, I just wanted you all to know what was going on and why we were doing it.
Next, what do you have next, Mr. Hollis?
Thank you, council. Your next 6
Thank you.
items are all airport-related, and your airport manager is here. Requesting your approval to apply for and accept a grant from the Maryland Aviation Administration to secure 75% funding, which is $291,851 for Phase 1 of the airport's obstruction removal project.
Mr. Rish, how are you?
Good evening, President Pack, Council. Thank you for your time. So, a lot to talk about. Obviously, we have 6 items. This is a testament that although COVID has hit and things have slowed down in one regard, the airport has not stopped planning. We've been quite busy getting ready for this new fiscal year. I will tell you, before I go through any of this, that these are the airport's priorities for the year. These are all funded, budgeted for. These were the top things. We cut other things out that we are not even going to bring to you this year. So these are the airport's priorities for '21. And a lot of these things are time sensitive, as you know, getting the grant in. The MAA grants have to be, fully spent and turned and closed out by June 30th of next year. So that's why we started on this process very early. The first 3 bullets that you have there They're really a package deal. They all three go together. They pertain to the obstruction removal project that we briefed on about 6 weeks or so ago out to the community center. It's the tree removal primarily off of the former Black & Decker site, off of Hazelwood, Brooks Commerce, a few there, and the Route 50 rest area up by the airport. So that is the tree removal project. The the MAA came through with 75% funding. We were pleasantly surprised by that. They were talking maybe only 50, so that's very good. They're offering 75%, $291,000 there. RJO Services is they won the award. I'm sorry, they won the lowest bid. So we'd also like to accept that today.
So Michael, let me do this a different
Okay.
way. Let me help you out. So council, we're going to go through these 3 items and for the record, make sure.
Yep.
We already talked about the first one with the 75% funding from MAA for the project. Number 2 is to award bid number 20-06 to the low bidder, RJO Services LLC, for the total bid amount of $388,785.75. And the third item Mike is requesting approval for is to accept AECom's price proposal for professional engineering and construction phase services of $55,676. The airport cost will not exceed $152,959.
That's correct. Yeah, this is a package deal. We need all 3 of those pieces to go together to make the project work.
Sounds good. Is there a motion?
So moved.
Mrs.
Second.
Callahan, is there a second? Second by Mrs. Price. Any further comment? Okay, hearing none. Madam Secretary, please call your roll.
Mr. Mack?
Aye.
Mr. Callahan?
Aye.
Ms. Price?
Aye.
Mr. Wiltshire?
Aye.
So am I combining any more before I start?
No, now we'll go single.
So
But they're all together.
You good?
I am, yes. So the next bullet is for a pavement management project for Taxiway Bravo. This was a high priority for us. The Taxiway Bravo serves our secondary runway, not to get too deep in the weeds, but it has not been properly maintained in about 10 years. We need to start the process of getting our secondary taxiway and the secondary runway in better shape in preparation for when we have to close the primary runway for the overall runway project. So this was also a priority. The pavement management, tonight I'm coming to you to just ask for the design piece of it, which is $14,000 and some change. I already have an offer from MAA to fund up to $60,000. So our portion of the actual construction cost will be $20,000, and that'll leave plenty of room in my budget to also award some construction administrative costs in the spring as well. So this entire package will be done for less than $50,000 total cost to the airport.
So the ask right now specifically is to accept AECom's price proposal for the design of pavement management project in the amount of $14,000.
That is the ask tonight, just to design the project. And another piece of this I'll point out is we're going to design it now and watch the revenues, right? So although this is a priority, we're still being very conservative and cautious and waiting stuff. So we'll design it, we'll have it on the shelf, and then we'll, pull the trigger and do it in the spring. That's the thought.
I'm sorry.
What? No, I was just going to say, do you need a motion to approve?
Now, I just was, so when you're talking designer, when you're putting, are you making like a new path?
No, it's not. It's just going to design the projects for us, go out there, do the material estimation, actually find the cracks, draw it up. They help with the bid process and all that. It's to design the project and, get it ready to,
But you're
for construction.
basically overlaying what's already there.
That's right. And it's not, exactly. It's going to be a seal coat that goes on top.
Gotcha.
Yeah.
Gotcha. Okay.
Is there a motion?
Yes.
Yes, second it.
Motion by Mrs. Price, second by Mr. Callahan. Any further discussion? Hearing none, Madam Secretary, please call your roll.
Mr. Mack?
Aye.
Mr. Callahan?
Aye.
Ms. Price?
Aye.
Mr. Wiltshire?
Aye.
Next is request to approve the contract with Delmarva Petroleum Services to replace the diesel and motor fuel pumps in the amount of $14,971.26.
Yeah, just quickly on this, the state came out, weights and measures last year, that those 2 pumps failed. They still have the old hand crank pumps on it, and those are not legal for selling. And we actually do sell a small amount to the fixed base operators to power their fuel trucks. The fuel trucks run off of diesel primarily, so technically it's not legal for us to sell them even a small amount of diesel because of those pumps are not metered properly. So the pumps are out of compliance, so we're going to replace them with a electric pump that'll pump both the gasoline and the diesel out of their fuel farm.
Is there a motion?
So moved.
Second it.
By Mr. Price, second by Mr. Callahan. There's no further discussion. Madam Secretary, please call your roll.
Mr. Pack?
Aye.
Mr. Callahan?
Aye.
Ms. Price?
Aye.
Mr. Lusher?
Aye.
Final item is requesting your approval to extend the current contract with the airport consultant AECOM for a period of 6 months. You want to explain that?
Yeah, so this is another COVID impact. Quite frankly, time ran out of the hourglass before we could get an RFP out for, consulting services. AECOM, they actually thought they had more time, but when the state said they had money to do the pavement project, we're like, we got to get this done so that we can, work on this pavement project, the pavement management that we just talked about. So the contract actually expired on just a few days ago, July the 10th. What I'm asking and what I think would be prudent is that we extend our current contract with them through the end of this year. That way we can get this work done that we have planned, and that will also give us plenty of time to put an RFP out for, to receive bids on, another consultant contract for 5 years.
Does Officer Law look at this? This is no additional verbiage in this contract?
Yeah, this is just a continuation of the terms that we're in right now with no changes to anything else.
Tony, have you had a chance to peek at this, or is there anything I need? I don't see any changes in it myself, but I just want to.
I'm not sure that.
No, we didn't actually. Tony and I have not talked about this. I didn't have. Quite frankly, I didn't think it would raise to that. I didn't have any concern that.
So 0 changes.
There's 0 changes. We just want to continue it for another 6 months under the exact same terms.
Okay. Mr. Hollis, good?
Yes.
All right, so.
Then motion.
Motion to.
To extend the contract to AECOM for 6 months.
And can we also include, and do we need to get a motion to do an RFP for the next contract? Can we combo that tonight? I love coming back, but.
Let me get to your contract first, which I'm kind of concerned that the Officer Law hasn't looked at yet, but that's okay. But is there a motion to, this is just a 6-month extension for AECOM for technical services at the airport?
Yes, they do a great job. I mean, I'm sitting in on those meetings, and they always come to the monthly airport board meetings.
They do.
We haven't had one in person in a while.
I'm
It's
very
tomorrow.
pleased with them.
But, no, they do a great job, so absolutely make a motion for that.
Is there a second? Second it. By Mr. Callahan. Any further discussion? Hearing none, Madam Secretary, call your roll.
Mr. Pack?
Aye.
Mr. Callahan?
Aye.
Ms. Price?
Aye.
Mr. Lusher?
Aye. And now, I was going to say, will we need a motion approval from them to go out to RFP for the new contract?
Well, I think since you're this far down that rabbit hole.
I mean, since we know we have to do it within the next 6 months, can we get permission now to put an RFP together to solicit another 5-year contract for airport consultants?
I would certainly recommend you say yes.
Absolutely, yes.
This is general consulting services.
Yep.
This does-
We have to rebid it every 5 years to make sure that everybody stays competitive. So that's what we'll put together an RFP, and we'll solicit for new engineers.
We have them for 6 more months, so
Yeah.
no
All
sense
right,
waiting,
so-
no sense waiting for the last minute.
That's right. We might as well get a start on it now.
If you'd like, I'll make a motion for you to have permission to go out for an RFP to
Thank you.
continue on.
Second it.
Okay. Any further discussion? Hearing none, Madam Secretary, call your roll. Aye.
Mr. Callahan?
Aye.
Ms. Price?
Aye.
Mr. Lusher?
Aye.
So Council, thank you, Mike.
I have one more note. I have a very important note. Nothing else to request, but, so the airport, obviously, we're self-sustaining and everything's great out there. I just want you to know that, these were priorities. These have been well-funded. So what I'm about to tell you, please don't get nervous about. The FAA did share with us, last week, as you know, we have some concern that we may not receive our AIP funding for this year. So over the past, if you remember what happened in 2018, just about a carbon copy is being set up, and they cited COVID and loss of revenue to the airlines is the reason why the funding is unstable. This is no surprise. We're going to start seeing this all over the place. We had put an application in for a little over $1.6 million in reimbursements, for our navigation easements, wetland mitigations, and the Forest Conservation Act cost, with all that. And as of right now, they've said that that has not been approved, and we are still competing for funding. So because of that, that's why I'm continuing to be very conservative with everything out to the airport, and just know that these are the priorities. There's other things that we're going to put on the table, or take off the table and put on the shelf. Watch the revenues. The revenues are strong. We have a very stable business model. I don't have any concerns, but I just want you to know that the grant funding may not come through this year.
Is the impact of that, would that be essentially moving the capital project schedule back a year, shifting everything back a year?
It possibly could. Over the next month, Mr. Hollis and I talked this morning. We're going to discuss what this impact would look like, and I'm going to put together a paper for you guys to review, and then probably come back in another month or so and talk about in a little more detail what it would mean. A work session, yeah. We are at the point, quite frankly, with there's so much happening dynamically. We have some things out at the business center, dates. We got to get this figured out, right? I'm working with AECOM, have a meeting this Friday to start looking at, we have to take a look at this funding issue and really come up with a realistic timeline. What can happen when out at the business center? We can't just keep, this, that, and the other thing. I know we all need a date. We all need a year, that'll help me plan, that'll help you plan, the sheriff, and everybody. It makes everybody's life better. So we're going to start working on that.
And and I do appreciate you letting us know that, and I agree, Ms. Hollis. We talked about this early this week about getting with you for a work session. Yeah. These AIP funding, is those through ticket receipts from travel and baggage receipts?
Yes, sir. That is exactly what it is. And obviously, the airlines were impacted. They lost their flight schedule by 90% nationwide. It's slowly coming back. They're up to 30–40%. So all those fees that are usually collected in the Airways Trust Fund, they're just not flowing in there. And I predicted this was going to be an issue. Now, this is sooner than I expected. I thought we'd kind of make it through the door this year and be impacted next year, but it looks like they're already starting to cut. Now, like I said, their official stance is we're still competing for funding, but that doesn't give me a warm fuzzy.
Is it possible that it would be partial, or do they kind of do the whole project or nothing?
You know what's crazy right now, Ms. Price, is anything's possible coming out of D.C. because when the Congress gets back and they start talking about this next round of stimulus, they could fund it. Who knows? We really have to watch what Congress is going to do. But that being said, we're putting all of our faith in what Congress is going to do. So that's why we have to be conservative.
They don't typically put stimulus, i.e. tax money, printed money, into airports because all of those fees from flying on airplanes, I mean, that's the one thing that's kind of nice about grants and things, and the funding that the airport gets, the 75% or 90%, is not taxpayer dollars.
That's right.
It's if you go fly and you pay a fee on your airline ticket, that's where it comes from.
That's right,
so
user fees.
This would be a departure, no pun intended, for them to do stimulus.
This is, I would think the stimulus would look like the CARES grant did. That's what they would do. They'll just push money to the airport district offices through a CARES grant program. Like we did receive that small 157,000 one. I'm hoping that they do that again, but a much larger number.
Okay. We'll look forward to the work session so we can try to get our timelines together and help you coordinate a little bit better at the airport.
Thank you, sir. Appreciate it.
Good?
Yes, sir.
Okay. So, council, you do have a request from Judge Kehoe's Circuit Court requesting approval to upgrade the court smart system in the courtrooms, one of which we're sitting in, at a cost of $25,282. Current equipment is categorized as end of life and needs to be replaced with upgraded hardware and software, which is our responsibility, in order to be able to migrate all the courtroom hearings to a cloud-based environment. These funds are included in your capital outlay. I share Ms. Price's concern about the $300,000 plus for the road equipment, but on this particular item, I'm asking you to approve it, please.
Is there a motion?
So moved.
Moved by Mr.
Second.
Okay, moved by Mr. Lesher, seconded by Mr. Callahan. There's no further comment. Madam Secretary, please call your roll.
Mr. Pack?
Aye.
Mr. Callahan?
Aye.
Ms. Price?
Aye, with the same concerns.
Mr. Lesher?
Aye.
2 letters of support, if you're willing, requesting your approval to send that letter on behalf of Critchlow Atkins Children's Center to the USDA for a community facilities grant. It's in the amount of $52,000. It would help offset the cost of furnishings, computers, and supplies for the new classroom at the Easton Elementary School. No county dollars would be involved.
Is there a motion?
So moved.
By Mr. Lesher.
Second it.
By Mr. Callahan. Any further discussion? Hearing none, Madam Secretary, call your roll.
Mr. Pack?
Aye.
Mr. Callahan?
Aye.
Ms. Price?
Aye.
Mr. Lesher?
Aye.
And the second of support letter would be for the Asbury United Methodist Church. They are submitting an application to Maryland Historical Trust in the amount of $100,000 for repairs to the church.
Move to send the letter of support.
By Mr. Lesher.
Second.
Second by Mr. and Mrs. Price. You had your turn already. Any further discussion? Hearing none, Madam Secretary, call your roll.
Mr. Pack?
Aye.
Mr. Callahan?
Aye.
Ms. Price?
Aye.
Mr. Lesher?
All right.
And Council, we did have an emergency services item on there, but we're going to move that to your next meeting. Mr. Stamp was feeling under the weather. So thank you.
Yeah, back here. Okay, Mrs. Moran, do you have my public comment list?
She just left for a second.
Oh, Mrs. Mark, okay. Well, see where she is with that. She's went past it. I'm just waiting for Ms. Moran to come back with my list.
Waiting for
Ms. Morris?
So while we're waiting, I'm going to go out on the limb that I hope no one will cut off and just point out that you do have 2 public hearings coming up on the 21st and the 28th. The public health officer is on record recommending against them in terms of the COVID pandemic and the numbers in Talbot County increasing. And the sheriff has indicated that he will not be providing deputies to a venue that is not sanctioned by the health officer. So while you may or may not be prepared tonight to give staff direction about where you're going to hold those hearings, I do want to be on the record telling you that the health officer says they should not be in person at the high school.
Thank you, Mr. Hollis. You have my list? Ms.
I do, but
Okay.
I have nobody signed up to speak.
Okay. You here for public comment? Come on up, sir.
I sent an email and I had to sign in.
That's okay.
Good evening.
Good evening.
I'd like to first thank the Lord Jesus Christ for salvation, the greatest gift in the world. And I won't be before you long. I have a prepared statement that I'd like to read to you, if that's okay. Good evening, council members. My name is Joe Brummel. I'm a husband, father, local business owner, an active member in our community, and a lifelong resident of Talbot County. I come before you this evening out of personal, social, and civic obligation. Personally, as a loving, caring father, speaking on behalf of my 9-year-old son, who has been subjected to unimaginable wrongs by the Talbot County public school system. As parents, I'm sure you can relate to the responsibility of protecting and advocating for the spiritual, mental, and physical well-being of your child. Socially, to make the community aware of what is going on in the public schools. Our unfortunate experiences as it relates to the mistreatment of our child by TCPS staff members. We're coming forward, telling our son's story with the hope it prevents another child and family from having to live through this hardship. Politically, we know the council has an interest in having a community that lives together in unity. We fully understand that the TCPS board members are elected by the citizens of Talbot County. However, the council is responsible for funding the majority of the school's budget and should be able to have the Talbot County Public School Board show accountability when children have been mistreated by their staff and policies haven't been followed to hold them accountable. I'm sure this is not what you intend to fund or consider appropriate use of funds. TCPS has arguably the best written policies out of the 24 public school districts in Maryland. When it comes to written policies, they seem to have covered all the bases to make a parent feel comfortable that they're making the right choice when they choose TCPS. They have excellent non-discrimination policies, protection policies to keep children safe from staff mistreatment, abuse, anti-bullying policies and protocols to follow when these incidents arise. When they talk policy, there's not much to debate. They have well-written policies. Unfortunately, the policies only work if they're abided by and enforced. TCPS staff has not abided by these policies nor enforced them. Before coming here this evening, my wife and I have done everything within our power to get justice quietly for our child. We have written multiple letters to the school principal, superintendent of TCPS, the TCPS board. We've attended meetings with the principal and superintendent. We've attended 2 hearings. The NAACP has accompanied us to numerous meetings with the principal and equity staff of the school he was attending. We've done our best to try to protect the integrity of the Talbot County public school system. We want the schools in our community to be places our citizens can trust. We're sending our children to a safe place to learn, grow, be treated equally and equitably. If you recall, my family and I were here as advocates for TCPS at a budget hearing. You'll notice by the dates on those documents, we were here to support TCPS even during the very time the staff was mistreating our son. Our son attended SMES, St. Michael's Elementary School, a predominantly white school. Children of color comprise approximately 25% of the student population, while white students make up the other 75%. Yet children of color account for 80% of the disciplinary referrals in the school. Our son was victimized by the staff at this school and their biased treatment of children of color. They failed to protect him. Even though they had the policies in place to guide them, they elected not to use them. You see from the documents how he was allowed to be bullied. Even with our following of the bullying reports, the administration failed to act appropriately according to policy. As a result, our son ended up in the hospital with a concussion. The documents show a distinct difference in how they handle bullying when a white child is involved. Our child was repeatedly mistreated by white staff members simply for being a child of color. He was told by the school's equity practitioner he was going to end up in prison for defending himself against a white student who carried out his threat to hit him. He was threatened by a white male bus driver for defending himself against a white student 2 grades above him. The bus driver alleged our child started hitting the white child for no reason. Bus video revealed the white child and a group of others had been bothering our son for weeks while he was sitting in the seat directly behind the bus driver. The following year, the same bus driver filed another false report alleging our son was pulling a little white girl's hair and punching her in the stomach. Bus video revealed the children were harmlessly playing with each other. It also revealed the bus driver screaming and yelling at our child while calmly and politely addressing the white students, all for displaying the same behavior. The same bus driver then littered our business property for months until the sheriff's office investigated and charged him. Our son was picked up by a white teacher and dropped slammed to the floor. The teacher alleged he attacked her for no reason. The video revealed the teacher grabbed him from behind and drop slammed him to the floor for playing tag in the hall with his friends. We requested, but the teacher was never reported to DCPS, much different than they handled the incident with the elementary child of color and the principal. That child they had arrested. The same teacher, months later, took our son in front of the classroom and invited the other children to antagonize him with her. There are many other instances I could share with you, but I believe you should have a clear enough picture of why we need you to require accountability and oversight of the Talbot County Public Schools, instead of allowing them to continue with these discriminatory and unlawful practices. Unfortunately, our son was not safe in the Talbot County Public School System. Due to their failure to hold their staff accountable, we had no option other than to remove him from Talbot County Public Schools. Private school is expensive, and no family should be forced to choose private over public because they fear for the safety of their child from the staff members. There are many other families of color experiencing the same difficulties with TCPS, but until now, there was no one willing to listen to our grievances. The school has been entrusted by every organization of the community because of their diversity statements and catchphrases, which has left the children of color and their parents at the mercy to be mistreated continuously. Council, you have the power to hold them accountable, and we ask that you hold them fully accountable. On behalf of my family, myself, and all the children who have been mistreated by the Talbot County Public School staff, we're very grateful for you taking the time to hear from us. Thank you for providing this segment in your meeting, allowing community members the opportunity to address you and our fellow community members. It's a terrible hardship to endure when your child is being mistreated, and we've been to everyone legally. We've been to the police departments, we've been to social services, we've been through the court system, and everybody says the same thing. Talbot County does a great job in their equity work, but they failed us and they failed our child. Everybody says you need to go back to the school system. Even when I called here and spoke here, they said, you need to go back to the public school. The public school, this is the public school issue. The public school has walled us out, trapped us out to leave our children at their mercy and be mistreated. In our last conversation, it's not because we didn't remove our child from Talbot County Public Schools because these things happen. We removed them from there because these things happened, and they failed to hold their staff accountable. In our last address with them, meeting with the head of student services, and I have the emails documented as well of that conversation, where she confirmed she refused us our right to the Freedoms Act, MPIA request. She refused us the documents that they had of our son. She told us directly that we were left at their mercy. You're going to have to trust us that we're going to do the right thing when they completely over and time again. And this is just a small list that I read to you of the things that's happening. We're talking about one child.
What grade is this?
This is from 2014, from when he started kindergarten up until second grade. When second grade is being in with the concussion, and we didn't remove him until after the conversations with student services, and they said, well, you're just going to have to trust us. We're not going to, you know what I mean? And the superintendent had the same attitude, and we have the transcripts from the hearings to validate everything that we're saying here is factual. Nothing has been done by the school system superintendent. We've been to MSDE. Everybody kicks us back to the same system. We've been to the board members. Everybody kicks us back to the same system, where just to allow our child to be mistreated and at their mercy. And we didn't have budgeted in our account for private school. We pay taxes for our child to go to a public school, and yet here we are accruing an expense that we didn't have budgeted for, because we fear for his safety and what this is going to do to him as a child over and over. When you talk of one child having these experiences with people of another race, what in this country is the majority race, that doesn't leave much for chance of success. If you're providing an opportunity for a child to be equally and equitably learn in this society, which everyone as a citizen should be afforded, this has to be looked into. This has to be stopped. We even went in the courtroom. Even the court system referred back, because the school system, and I didn't know this until then, but because they are declared as people of authority, they will not challenge one another. That's left us in a horrible position.
So is there current pending legislation?
Pending legislation? Well, we hired an attorney.
Litigation, I should say.
Well, we hired an attorney, one of the best, highly sought-after firms here in the county. And come to find out, after 9 months of just dragging their feet, we did look into that, and it's against the law for them to do that, but we found that his wife works for the Talbot County Public School System. He never disclosed this information to us at all. So, and then 9 months later, which pushed us past the 2-year, which pushed us exactly past the 2-year, the mark that you have to
Statute of limitations?
Statute of limitations. Thank you, Mr. Price. I was trying to get to it. That's why I wrote it down, because it's emotional to me. You know, you see it happen to any child, but when it's happening to my child, and we've done everything that we could, even legally. We hired this firm, and they waited right until the statute of limitations was out, because it was April 2020 when the hearing ended. We retained them July 24th of 2019, which left us plenty of time. When we reached April of 2020, he became very combative, didn't want to do the things that we had. And it took him that amount of time to have 3 correspondences with the school system. But he billed us every month, right up until June. And then in April, he discloses us through a virtual meeting that his wife works for the Talbot County Public Schools, so he can't put his name on the document. He's got to have another attorney put it. I said, if we had known that, we never would have hired you. And that is yeah, that's a conflict of interest. Not only that, the amount of time that he took to do that and billing us for it, that's another issue with the Attorney Grievance Committee. But what I'm saying to you, barring all that, my child, regardless of what I'm living through or lived through, my child has a right. He has done nothing to anyone. He's 9 years old now. He has a right to grow up in a world where he's not treated like that. And if he is, then it shouldn't go unnoticed or unchecked. It's heartbreaking. And like I said, we've done everything. We've been to the meetings to support them, because we know that the public school needs things in order to properly educate and to treat children properly. But it's not happening. It's just not happening. They don't have a desire in it happening. And when you look at their equity policies, it's not that they don't have the knowledge of, but they've used that knowledge of as they've never said this to me, but they've used that knowledge of, and what I've seen in the evidence of how my child has been treated, they've used that knowledge as a way of manipulating the system to come and get funds for you to do whatever they want to do. So if you're even though you don't elect them, if I'm giving somebody money, I have a right to ask them and demand of them to know what they're doing with that money, how this money is being implemented and benefited the community that I intend to support. So I'm asking you, I know you can't go in there and do, but you can hold them accountable for these monies that you allocate to that budget to make sure that children are treated equally and fairly. My child left a lot of friends behind at that public school, and you know, it was heartbreaking. We haven't told him the real reason why he left. We just told him this is a better school of more of what we believe in, you know, because we don't want him growing up with that stigmatism stuck in his mind that people don't like me because of my color. So we didn't fully tell him why we moved him, and we truthfully told him, you know, this school is more of what we believe in. We think you'll have a better opportunity to learn and grow and move forward through life going here. Not telling him why we had to move him or what it's costing us to move him.
Well, Mr. Brown, I certainly sympathize with what you guys have gone through.
Thank you.
It's really, really shocking to hear. And certainly thank you for waiting around such a late hour to speak to council about this. Yes, they're an elected board as we are an elected council here, so
Yes.
Our oversight is somewhat limited. And I know you did send also some supporting documentation as well. So
I have a lot more, but I didn't want, I'll give you whatever you request. I
Well,
have a terabyte of cloud storage, and I have 2 duffel bags full of documents just for that one child.
And this is a second grader we're talking about, so this is.
He just passed the 4th now. We removed him there. He's been his last year in private school, and he'll be returning there. But he, you know, but for all those other children, we can't afford that either. But for all those other families who can't either, why should we have to?
I understand.
You know what I mean? And this is not abuse by children. This is the staff that they have prided themselves in training the policies that they have touted around being #1, and they are great policies. If you read them, I've read them in and out. So they are great policies, but they're just not enforced from the bottom up to the top in reverse. They're not holding anyone accountable.
I wish I had a quick answer for you tonight, which I don't. I mean, I think this council will have to look at what our options are as far as working with the Board of Education for any response to your allegations.
Sure.
We could maybe draft something and get over to them and have them respond back to us. You said right now there is no pending litigation.
Well, we're talking to firms up in Baltimore, and I mean, but the statute of limitation passed.
Okay.
So this is only validated when you can show the continuous treatment of staff failing to protect him. So in 2018, that cut that off. I mean, April 2020, that cut that off. Now it's just one isolated event within that 2-year period that you could bring up. So the people that we're talking to, and we're talking to firms in Baltimore, and if they're not hopeful, then, you know, it's really, I mean, it's just a shame that this is a tight-knit community, a tight network, and if you are the people who have the power to break it apart, because you have the money. Without the money, you can't do anything without that. So, and if you ask them to show accountability down to the letter, what you're doing with these funds, then that would make what you're doing more transparent to us and to the community. So when we have these complaints, we know how to respond to them because we funded your organization. So, I mean, I don't know if, I do wish it was something that you could do, because I would love to see my child be able to tell them the true story, full story of how this happened and how we came into a community and the community came together and then we resolved these differences so that your sacrifice and your mistreatment was not in vain, it was not for nothing, but other children will benefit, that they won't have to endure this. So I know.
Again, you gave us a lot to consider, and again, I certainly appreciate you standing around and giving your testimony to council. We're going to need to probably huddle up and find out how we can request any comment from the Board of Education back to us based on your comments here this evening. And,
I'm so sorry for everything you're going through.
Yeah.
Thank you. That's the first. We never heard that from the school. That's the first time we've heard that from anyone.
That's terrible. And
I'll thank you. I really thank you for saying that, because we haven't received anything but doors slammed in our face, screamed, yelled, cussed at, and I couldn't understand that. You're the people who are educating our children.
Sometimes I wish we could hold the school board a little more accountable for how they spend the money. It's state mandate. We don't have any control over what they do with it. It's not like we can hold it back from them, but certainly I hope that we can ask some questions, and if you didn't get good legal advice, you might be able to, I don't know, I'm not an attorney, statute of limitations,
Right.
because you know, it ran out, but it's not because you weren't trying, so hopefully somebody can help you with that. I really hope
Yes.
they can.
I do too.
I appreciate your bringing this
Thank-
to our attention,
Yes.
and I only wish that all of our parents were articulate advocates for their children as you are.
Absolutely.
I love children. I love my
That-
children, but I love all children. I'd do anything for them. It was worth sitting back there on that bench, and I would do it again every day. Thank you. Thank you all.
Yeah, appreciate it.
If you need any more documents or information, I have it. So,
And you know this, what Mr. Lesher just said, it makes such a difference when parents are involved. I mean, and you can't make perfect kids or anything, but it just, when they're involved in their lives, it just makes such a difference for their future. So thank you for being a wonderful dad.
And I want to thank you too, because what you ought to do, this is on tape, and your son needs to see this in years to come, what his father did for him. And you've done in your family. So that's a milestone to your integrity and who you are, and we really appreciate it. And I wish we had more people like you to come in front of us so we could take care of some of this stuff.
thank you for making it possible.
Yep,
Mr.
thank you.
Thank you all. I
Thank
know it's
you.
late. I know you have families too.
Yeah, best to your family.
Thank you. Enjoy your evening.
All right, council comment, Mr. Callahan?
I'm good.
Okay, Mrs. Price?
Just thank you to the people that are out there, all the letters of support. It's been a rough few weeks, and I appreciate all the outreach. It's very much appreciated.
Mr. Lesher?
I have nothing further.
Let's see here. County Council's next meeting will be on July the 21st. That's going to begin at 6 p.m. It has been declared a special legislative day. The council will be convening in closed session at 4:30 and then immediately adjourning into closed session to discuss real estate, legal, personnel matters as listed on the statement of closing that meeting. That meeting was to take place at the Talbot County Auditorium, but after consulting with the health officer and hearing her concerns, the county's positivity rate, which is now jumped up to about 7.7, and also a number of confirmed COVID cases have now nearly approaching 200. The health officers thought it was best to not have that public hearing at the auditorium at this time. So we'll work out the details of perhaps a virtual hearing for the 21st. There's also a hearing scheduled for the 28th. That hearing was also to take place at the Talbot County Auditorium. Likewise, I'm almost certain that these numbers, that is the positivity rate as well as the confirmed rate of COVID cases, will still be high on the 28th. So we're going to probably need to have that as a virtual hearing as well. And that information will be posted later this week. Thank you. If there's nothing further, Madam Secretary, on your agenda for us, we're adjourned. Thank you.